Excuse me, please, Your Lordship. I beg to mention item number 1.
Yes.
My Lord, we are for the petitioner hearing, Your Lord, respondent, Your Lordship. May I,
Respondent.
yes, Your Lordship. May I pray that the matter may be taken up after the break, Your Lordship?
Taking consent from the other side.
Yes, Your Lordship.
Yes.
I will inform.
Okay. You are Mr.
K. Lawrence.
K.
K. Lawrence.
Counsel for the appellant is present. Ms. D. Amuk, counsel for the respondent. Praise for listing this matter after
Vacation, Your Lordship.
the ensuing summer vacation, to which Mr. D. Loyal counsel for the
K. Lawrence.
Hmm?
K. Lawrence.
Okay. As no objection, the prayer is allowed. List this matter after summer vacation.
Because there is an interim order.
Interim. The interim order pass earlier will continue till then. Okay.
Obliged.
Obliged, Your Lordship.
My lord. Yeah, my lord. I will mention item number 9. My lord.
9.
My lord, allow me to withdraw this application. Ma'am. Allow me to withdraw this application.
You want me to do this petition?
Yes, ma'am. Both the
Yeah.
party has attended
Okay.
outside the court.
You're Mr.
The other.
For a petitioner.
Yes.
You are
The other. The other.
Mr. D. Ado.
Yes.
Learned counsel for the petitioner. Has an instruction to withdraw this criminal petition. And prays for allow him to withdraw the same. The prayer is allowed. Accordingly, the criminal petition is disposed of on withdrawal. Okay, withdraw. Okay.
My lord, again in item number 16 and 17 and 18. ma'am. This matter may be taken up after my lord vacation. ma'am.
After
Vacation. ma'am.
you have taken consent from the other side.
Yes, ma'am.
Yes, my lord.
Okay. On the prayer of both the learned counsel for the petitioner and the response. Your
In item number
you are in
16 and 17, I am for the respondent.
you are for respondent. You are for a petitioner.
He is for item number 16, he is for petitioner. And item number 17, government advocate. We have
Yes,
take
for the item number 16, respondent number 1.
Okay. You are Mr.
The other. ma'am.
You are learned counsel for the petitioner and Mr.
T. Minky, madam.
T.
T. Minky.
Minky, learned counsel for the respondent. Prays for listing this matter after vacation. The prayer is allowed. List this matter after vacation. That is for 16. 17, you are
17, I am for the respondent. my lord.
respondent. Okay.
Yes,
Then in 17 again is Mr. D.
So I am not in.
In 17 you are
no, he is not
I'm not.
represent. In 17, government
They
advocate.
all are connected. madam.
so connected.
Yes, my lord.
Then you say that the government in 17 government is the appellant.
Yes, my lord. We have take consent, my lord.
Consent.
Yes, my lord.
Okay. Then you say on the joint prayer of the learned counsel and the respondents, list this matter after the ensuing summer vacation. Okay. In all cases, 16, 17, and 18. Okay.
Deeply honest.
Yes.
I think the item number 19. On
Okay.
behalf of the
19, yes. Monday. It may be fixed on Wednesday, my lord, next week.
Next one.
Wednesday, my lord.
Next Wednesday.
Yes. So long pending matter.
Is it okay for you? Okay. Page prayed for by the learned counsel for the petitioner. Okay. On the joint prayer made by the learned counsel for the petitioner parties, this is matter again on Wednesday is where? Sorry, 26.
Yes, 26 one.
Okay. 26.
Obliged.
Okay.
May I please?
Best mention after 20.
Item
20.
20.
On Monday.
Monday. What is this matter about?
Appeal against the order passed with that first update.
Okay. Have you informed the other side?
Yes.
Okay. Mr. S. Tapin. You're on behalf of the government here.
No.
Okay, Ms. S. Tapin, I'll counsel for the appellant. With the consent of the other side, praise for listing this matter on
24.
24. There is a list this matter on 24.
All right.
Item number 21.
May it please your lordship. Lordship, the petition seems to be very bulky, but then it contains much more of the documents, your lordship.
Hmm.
Your lordship, in this matter, what has happened is that there is a money suit pending before the CJM court, Bomdila, your lordship.
Hmm.
Now,
What will pass by?
we,
Season Bomdila.
Civil Judge, Senior Division, Bomdila, your lordship.
Okay.
Now, we have filed an IA in that money suit, praying for adducing additional document, which was rejected, your lordship.
At what stage you have filed this application?
At the stage of written, today, now the stage is of written statement,
When the
filing of
petition-
written,
When the petition was filed initially,
2016.
16.
Now,
24, you are,
yes, now the case does not simplify as to from 2016 to 2024, your lordship.
Okay.
The stages of the petition is that money suit was when filed, your lordship. Your lordship is well aware that the civil court was not in existence in Bomdila.
those days.
There was circuit court in Seppa, your lordship.
yes.
2016, we have filed the money suit, your lordship, wherein our petition with regard to jurisdiction of the court was challenged before the High Court, your lordship. The High Court, in that revision petition, had partly allowed, your lordship, in 2018. After 2018, again, when the matter was returned back to the civil judge, your lordship, we had withdrawn. That withdrawal was again challenged by the defendant in the CRP before this honorable court in 2018, your lordship. 2019, the CRP was disposed of, stating that there is a circuit court in Seppa. However, withdrawal could not be allowed, and there was a
Circuit court at Seppa or Bomdila?
Bomdila, sorry, your lordship, Bomdila. Now, the CRP was disposed of with a direction to return the plaint, and therefore the plaint was returned in the year 2019. From 2019, your lordship, till 2022, there was no court sitting in Bomdila. Meanwhile, we had also filed a transfer petition before this honorable court. During the pendency of the transfer petition, that's when in the year 2022, the permanent court was of civil judge was established in Bomdila, and therefore this matter has regularly been coming, your lordship. Now, from 2022 to 2023, your lordship, the matter has restarted with issuing of fresh step upon the defendants. The defendants making their presence, filing of written statement, your lordship. Now it is at the stage of filing of the written statement. Now the
Whether the respondent or defendant has filed already filed written statement.
defendant number 1 and 2 has filed a written statement, your lordship.
Respondent defendants are-
For respondent, your lordship.
Four.
The 5th is the firm. Now, in June 2023, the defendant has filed an IA for deleting their name as a party from the money suit, your lordship. Now,
Defendant number?
3 and 4, your lordship.
Okay. Now
Now, only at this stage, the hearing of
now
the
only 1 and 2.
no, it has not been deleted. That hearing is to be taken place on the next date, your lordship. The IA, they have filed an IA for deleting their name from the money suit, your lordship.
Okay.
So that
They have filed for deletion of the
their name from the money suit
defendant number 3 and 4.
for your
They have
lordship.
filed objection.
Therefore, your lordship, this application is still pending, your lordship. It is to be heard, your lordship. Now, during the pendency of their consideration of their application, we had meanwhile filed an IA for adducing additional documents, Your Lordship.
Now, in the meantime, whether the defendant number one is.
No.
already filed written statement?
Yes, Your Lordship.
Okay.
Now, if I may take Your Lordship to the impugn
When they
order.
have filed their written statement.
Your Lordship will. It was on, they had appeared on 17th of April 2023, Your Lordship, and they filed it on 27/6/2023,
Written statement.
written statement.
And then when.
And the impugn order has been, impugn order is of dated 9/2/2024, Your Lordship.
They have filed 23.
Yes, 23.
And when did you file this application?
Our application was filed on in the year to 2023, Your Lordship.
After filing of the written statement.
After filing of the written statement.
Okay, then. Impugn order pass.
Yes. Rejecting our prayer for adducing additional documents. Now I'll just clear to that prospect, Your Lordship. Yes. Order 7, Rule 14. Sub Rule 1 clearly says that the list of documents has to be with the plaintiff, Your Lordship. There is an exception to Order 14, Order 7, Rule 14.1.
Along with your plaint, the document must have filed by you also.
Some of the documents,
Why you kept the rest?
because some of the documents were, half of the documents are the counterfoils, Your Lordship. We could not get it. It was not with us, Your Lordship. It was misplaced. And we have given the reason. Even in the plaint, we have craved leave of the Honorable Court for adducing additional documents in our plaint, main plaint. These are therefore, the documents that are we are to adduce, Your Lordship. We have mentioned the period from month of 2016 only, Your Lordship. Those counterfoils, to substitute that there is a document we have where there is a record book, Your Lordship. The payment of money has been recorded in that book here. That the counterfoils and the account details of the petitioner is the substitution of that documents, Your Lordship. There is no extra documents out of when the cause of action arose, Your Lordship. Now, if I may just take Your Lordship to the impugn order.
Please.
Page number, Your Lordship will see last 628, Your Lordship. 28.
28.
That is the last, almost last pages, Your Lordship. 628.
628.
Yes.
Yes.
I won't trouble Your Lordship with reading the entire order, Your Lordship. If Your Lordship come to the paragraph, fourth paragraph, it starts from the petitioner plaintiff has filed the instant IA.
Fourth paragraph.
28, page number 628. Fourth paragraph, Your Lordship.
Yes.
The petitioner plaintiff has filed the instant IA under Order 7, Rule 14.3, Your Lordship will also record, of the CPC with a prayer to allow the petitioner to adduce the following documents. First is copies of check and letters of credit issued by the commandant officer SS Impress account supply, copies of counterfoils of bank deposit, copies of statement of account of plaintiff, and copies of account statement of dependent number 3. Along with, in respect of supply point, Dapurijo along Tuting, Monigaon, and Mechuka with effect from 18/7/2015 to 27/4/2016. This was the prayer made in the IA. These are the documents which were to be adduced, Your Lordship. Now, Your Lordship will come to page number 632, which is the finding of the court, Your Lordship. If I may read from the second paragraph, Your Lordship.
Yes.
Therefore, from the above discussion, the court is of the opinion that petitioner plaintiff firstly has the duty to mention about the documents which he now intends to adduce in the plaint, as he had the knowledge about the said documents and it was in his possession. However,
Did not mention. Okay.
However, the petitioner plaintiff has failed to discharge his duty. Secondly, the petitioner plaintiff has failed to convince this court through this petition and submission that the document which he now intends to adduce were lost at the time of filing of the plaint, and it was found during pendency of this suit. As no reasonable man would fail to describe about the documents on the basis of which he relies to make a claim against other persons, specifically when the documents consist of more than 450 pages. Thirdly, This instant IA has been filed by the petitioner plaintiff only after filing of IA number 4 of 2023 by the defendant number 3 and 4. This IA is for deleting their names, Your Lordship. And therefore, it appears that the plaintiff is filing up the lacuna in this case after more than 6 years from the date of the filing of this plaint, Your Lordship. Now, on this 3 ground, my prayer for adducing of the additional document was rejected, Your Lordship. Now, if I may take Your Lordship to the plaint, since there is a mentioning of the one of the ground is for the plaint, there was some mentioning of. If I may take Your Lordship to page number 26 of my plaint, Your Lordship.
26.
26. It starts from 24. Start from 24, and the relevant paragraph I'm relying upon is at page number 26. Now, Your Lordship will see, if I may read paragraph 4, Your Lordship. That the plaintiff begs to state that the cause of action has arose when the plaintiff credited his check in the account of Junglard Cooperative Society since from date on 16/6/2015 to 13/11/2016. Now, Your Lordship will see the transaction mentioned, cause of action arose between this period, Your Lordship. Now, if I may take Your Lordship to the next page.
Just a minute.
Yes.
This sentence. Credited his check in the account of since
16/6/2015.
16.
Yes. So this is the period when the cause of action arose, Your Lordship. Now, if I may take Your Lordship to page number 27.
That is in 2016.
Yes.
15/16.
Yes.
Okay, so that
Or specifically, even the dates are given, Your Lordship. At next page, Your Lordship will find
yes.
paragraph 5, that the plaintiff begs to state that with effect from 16/6/2015 to till 1/11/2016, various checks has been deposited in the account of the defendant, wherein 7% is deducted by the defendant number 1 and 3% is deducted by defendant number 2 till 31/3/2016, and therefrom 1/4/2016 to 30/11/2016, so and so has been deducting. Now, we have mentioned from the period, Your Lordship will see this money suit specifically mention of all the depositions in the form of check and deposition in the account, Your Lordship. Now, if I may take Your Lordship to page number 28, last paragraph, that is paragraph 10. Your Lordship will, if I may read, Your Lordship, the plaintiff begs to state that he shall rely on photocopied document list whereof with plaint. The plaintiff crave leaves of the Honorable Court to file original document and reserve for submission of additional document at the time of hearing, Your Lordship. There is a prayer sought from the Honorable Court craving leave for filing additional documents, Your Lordship. Now, if I may take Your Lordship Your Lordship will come to page number 30. Starts from 36, Your Lordship, the annexure that was annexed along with the plaint, Your Lordship.
36.
Receipts. These are transferred by check, the counterfoils, Your Lordship. And the record in the book, Your Lordship, will come directly to page number 62.
These are the documents which you wanted to produce.
No, this was annexed in the main plaint. This is in the main plaint. Page 62, Your Lordship. This is the record book of the plaintiff, Your Lordship. Yes, Your Lordship will see the dates are given, the transactions are given, Your Lordship.
The annexure.
In the plaint, Your Lordship. Now, Your Lordship will see, I have craved, there was nothing as such that I have never craved the leave of the court, Your Lordship. There was a prayer made thereby for craving the leave of the Honorable Court for adducing additional documents during the period of hearing, Your Lordship. Now, if I may take Your Lordship directly to the IA that I have filed, Your Lordship, which is at page number 109.
No, just a minute. What is this document? Page 62?
Page 62 is the record maintained by the plaintiff of the deposition of the money, Your Lordship.
By this, what you want to show?
I'll be coming to that, Your Lordship. I'll just, the showing that this amount has been, from the dates are given, Your Lordship. Transactions are given, Your Lordship. The total amount money has been given, Your Lordship. And the percentage of that deduction that was made, Your Lordship, has been clearly reflected in this record book. Also, in which account the deposition was made. Receive amount, Your Lordship will see the column in receive amount. To which account detail is also given, Your Lordship. Date is given, deposit is given, the account details are given, Your Lordship. This was only the record in possession of the plaintiff, Your Lordship. These all documents, along with other counter files and some of the checks, were already annexed in the plaint, Your Lordship. Now, if I may take, Your Lordship, to page number 109.
Yes.
109 is the IA for adducing of the additional documents, Your Lordship. There is some, Your Lordship will come to page number 100 and for adducing of the additional documents, Your Lordship.
In this IA?
In this IA only that impugn order was passed, Your Lordship. At page number 110, Your Lordship will come. Your Lordship will come to paragraph 2.
Yes.
That the plaintiff begs to state that at the time of filing of the instant money suit, the plaintiff could not bring certain documents on record before this honorable court. The applicant begs to state that he has found significant documents which he desired to rely upon and which may be substantiated to prove his case and proper adjudication of the case in hand. Serial number 4, Your Lordship will find, the applicant begs to state that the document mentioned herein below were misplaced, not lost, as reflected in the impugn order, Your Lordship. Misplaced during the filing of the instant suit, and that he has found the same during the pendency of the instant suit. Hence, the applicant desired to rely on the relevant documents which are necessary. Now, 111, page number 111 is the documents that is to be relied upon, Your Lordship. Now, if Your Lordship comes to all the documents,
Yes.
which starts from page number 114, Your Lordship. All of the documents are nothing but counterfoil, check, detail of the bank statement of the plaintiff, as well as detail of the bank statement of the.
These are the necessary documents to be exhibited.
Yes, Your Lordship will see nothing out of when the period of cause of action.
File these in the beginning.
Yes, Your Lordship,
What are
the
documents?
reason given is at paragraph 4, Your Lordship, that it was misplaced when the plaint was filed. Now, if Your Lordship will check all the documents, nothing is the period that I have mentioned in my plaint, Your Lordship.
Now, in a written statement, say, for example,
Yes.
if they have said something, then with the filing of this additional document, probably there will be substantial change in the.
No, therefore I was pointing out to the paragraphs in my plaint, Your Lordship. Your Lordship will see it.
Now, over and again, they'll have to file again.
No, Your Lordship. I'll come to that, Your Lordship. In our plaint, we have clearly made some statement that the cause of action arose from which date? It arose from the date 16/6/2015 to 30/11/2016. We have clearly even reflected, we have deposited, credited in his check in the account. We have given the detail also. Only the fact is that, Your Lordship, how can I mention all these documents one by one along with the check, Your Lordship?
They could have filed the documents.
Yes, we have filed half of the documents. Half of that it was misplaced during filing of the plaint, Your Lordship. And therefore, subsequently, when we found it, we have, therefore, the IA was filed praying for adducing of those additional documents, which is not beyond the period of cause of action or not prior to the cause of action.
The trial court probably has made an observation that since 2016, till 2023, you did not take any steps.
Yes.
To file.
Yes,
And then there has been a lot of litigation in between.
no,
And during this whole period, you did not.
yes,
And then normally, the entire documents,
yes.
including everything, excluding nothing, is to be filed along with the claim.
No, Your Lordship. Therefore, I was coming to Order 7, Rule 14, Your Lordship. Order 7, Rule 14, 1 says, if I may read, Your Lordship, Order 14, Rule 1 says that the documents has to be annexed along with the plain. Order 7, Rule 14, 3 makes an exception.
Yes.
If I may read Order 7, Rule 14, Your Lordship.
7.
Rule 14. Rule 14. Order 7, Rule 14, if I may come, bring Your Lordship notice at, yes, production of document on which plaintiff sues or relies.
Yes.
14.1 says, where a plaintiff sues upon a document or relies upon document in his possession or power in support of his claim, he shall enter such documents in a list and shall produce it in the court when the plaintiff is present by him, and shall at the same time deliver the document and a copy thereof to be filed with the plaintiff. This is 1. We have filed under Order 7, Rule 14.3. Now let's read Rule 3, which says, a document which ought to have been produced in court by the plaintiff when the plaintiff is presented, or to be entered in the list to be added or annexed to the plain, but is not produced or entered accordingly, shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. And
So he has exercised his discretion.
Discretion, Your Lordship. Now, if I may take, Your Lordship, therefore my submission with regard to that was that it is in the stage of filing of the written statement, Your Lordship. Now,
Let's see the revision.
Your Lordship,
The revision.
Your Lordship,
You have filed this revision under section.
115 read with 151, Your Lordship.
It's not a question of jurisdiction. It's a question that you satisfy them that the C have acted in exercise of its jurisdiction illegally or with material irregularity.
Yes, material irregularity. I'm coming to that, Your Lordship. The court has to, under 14, Your Lordship is now have gone through Order 7, Rule 14, Your Lordship, 3. It says that on the in the later stage also, additional document can be with the leave of the court. And therefore, the IA was filed praying for leave of the court for adducing additional documents. The very first ground that my IA was rejected was that, first, that we have not craved the leave of the court. We have craved in our plaint that I have showed in paragraph 10 of my plaint, Your Lordship, for adducing. Secondly, that
What material irregularity the Government Trial Court has committed?
yes, I'm coming to that, Your Lordship. I'll substantiate that with my with the judgments of the apex court. Now, the second ground on which it was rejected was that how could any prudent man lose his receipts? That was
definitely.
second ground. Third ground is that since an IA for withdrawing the name of deleting the name of the respondent number, defendant number 3 and 4 are given, and therefore he just to make fill the lacuna in the plaint he has given. Now my submission before this honorable court is the honorable civil judge failed to take into consideration that the cause of action, the period that I have mentioned, is very clearly reflected in my statements, Your Lordship. Period of, if any documents that was prior to or post of when the cause of action arose, Your Lordship, the period given, I wanted to adduce any documents prior to or after, post that period, the Honorable Court could have rejected that. That would have been a different ground, Your Lordship. The second ground, Your Lordship, that in my plaint, I have clearly made the defendant number 3 and 4, Your Lordship. I've also written in my
That's what I'm
statements.
saying. The court would have was accepted also.
Yes.
But then he has exercised his discretion. How do we interpret?
But I'll come to that, Your Lordship. The second is that when he says that only because the IA has been filed by defendant number 3 and 4 to delete their delete their name, and therefore to fill up the lacuna, we have filed the IA. Now, Your Lordship will also see that the paragraph that I have made Your Lordship go through in my plaint is clearly reflects that I have clearly stated that I have deposited the amount in the account number of respondent number 1, 2, 3, and 4, Your Lordship. That was not taken into consideration. There was no lacuna as such. Thirdly,
Then deposited in the name of 1, 2, 3, and 4.
yes, Your
So
Lordship.
then they can't be removed.
Yes.
They are the necessary
Therefore,
parties.
the reason given by the civil judge that only because they have filed an IA and we wanted to fill up the lacuna in our plaint, and therefore I had filed the IA for adducing of additional documents. That was the ground given, Your Lordship. The third ground that I have lost, Your Lordship. Therefore, I had brought Your Lordship to paragraph 5 that I clearly did not write that I had lost. I had misplaced it. And later on, during the pendency, I have found. It is clearly reflected in my IA, paragraph number 4, Your Lordship. Now, the question before this Honorable Court is that Order 7, Rule 14.3 clearly gives me a liberty to come before the court, craving the leave for the,
Yes, yes.
I have the full right to approach the court.
Yes, you-
Now, what are the courts to be considered is at what stage the plaint is pending, Your Lordship, the stage of the suit, Your Lordship. Secondly, if the documents that I have filed is beyond to my pleading, that has to be looked into, Your Lordship. Now, if I may take produce some of the judgments, Your Lordship, of the apex court. This is of 2013, Your Lordship. I'll start with paragraph 2, Your Lordship. The learned single judge by this order dismissed the application and said above order was upheld by the division court, seemingly on the ground that the matters were ready for hearing and were at the stage of cross-examination. Accordingly, such prayer could not be granted. Having heard the learned counsel for the respective parties, we are unable to agree with the decision of the division bench, as also the single bench, as we have been informed that the cross-examination has not yet commenced. In such a situation, we see no reasons for debarring the appellant from filing the additional document in support of his claim. Even in this judgment, Your Lordship, the only criteria that the Honorable Apex Court considered was that the stage of the suit, Your Lordship. In our plaint, even the framing or charge framing of the issue has not even started, Your Lordship. Next date is only for hearing their IA for deleting their name. If their names are deleted, meaning they're gone from all the allegations in the money suit, Your Lordship. The next judgment, Your Lordship, I would like to rely upon is, this is also of the apex court, and this is a very recent judgment of 2022, Your Lordship. I'll read from second paragraph where it starts from, we find that the trial court. We find that the trial court as well as the high court have gravely erred in law in not permitting the defendants to produce documents, the relevancy of which can be examined by the trial court on the basis of the evidence to be led, but to deprive a party to the suit not to file documents, even if there is some delay, will lead to denial of justice. It is well settled that the rules of procedure are handmaid of justice, and therefore, even if there is some delay, the trial court should have imposed some cost rather than to decline the production of the documents itself. The only difference in this judgment is that Order 8 is with regard to the defendant, Order 7 is with regard to the plaintiff's, Your Lordship. Even here, the Honorable Court has clearly said that delay cannot be a ground for not allowing a party to adduce their evidences. The next judgment that I would like to rely upon is of our own Honorable High Court, Your Lordship. It's of 2009. Lordship will, the relevant paragraph is paragraph 6. If I may read, Your Lordship.
Yes.
Order 7, Rule 14 CRPC provides for filing of the documents relied on in plaint. Order 7, Rule 14(1) provides that if the plaintiff sues or relies upon a document in his position of power, he is required to produce or annex such document in the court when he presents the plaintiff by delivering a copy thereof along with the plaintiff. Order 7, Rule 14 further provides that if the plaintiff relies on any documents which ought to have been produced in court when the plaintiff thereof, the same could be produced at a later stage of the suit with the leave of the court, provided such documents are produced for cross-examination of the witness of other party or handed over to the witness merely to refresh his memory under Order 13, Rule 4. A bare reading of Order 7, Rule 14(1), it is seen that if the plaintiff sues upon a document in his position of power, he is required to produce such documents in court at the time of presenting the plaintiff by delivering a copy thereof to be filed with the plaintiff. The said provision has been slightly relaxed under Order 7, Rule 14(3), to the extent that the plaintiff may be entitled to produce these documents to utilize the same in evidence with the leave of the court at the time of hearing of this suit. Thus, it is clear that if the leave is granted, such documents can be produced and or used at the later stage. And also, there is no absolute prohibition to the effect that once the plaintiff has not produced such document at the time presenting of the plaintiff, he is precluded to do so for all times to come. Paragraph 9, Your Lordship will see. In the case at hand, it appears that the document which has been sought to be relied upon by the plaintiff at this stage had been filed along with the application praying from necessary leave of the court, and the court has granted the leave by impugn order so and so. In such circumstances, it cannot be said that the mandatory provision of law has been violated by the learned trial judge in passing the impugn order. It's in as much as the claim of the plaintiff is non-payment of necessary bills raised by the plaintiff towards treatment of various employees of the defendant. This line is very important, Your Lordship, that being the basic claim of the plaintiff, as can be found out from the paragraph 6 of the plaintiff, the contention of so and so has no foundation. Now, Your Lordship will see the bills, all the bills could not be brought into the notice of the Honorable Court in this case, Your Lordship. Subsequently, he had craved the leave of the court, which was allowed by the trial court. Now, that was challenged in this court. Now, the Honorable Court clearly says the reflection in the paragraph is itself is the basic claim of the plaintiff, Your Lordship. Now, in Your Lordship, I also have a prayer for interim, Your Lordship.
Let it come.
Yes. Why? Because on the next date, the IA, there is
Let the notice go first,
no, Your Lordship. Why am I interim, Your Lordship?
because you say that the other IA is also pending.
Yes. The next date is fixed for consideration of the IA for deleting their name.
Yes, yes.
Now, if Your Lordship does not state, and if their hearing is happen, and if their names are deleted, Your Lordship, both the defendants goes. My claim towards those defendants does not even carry meaning in my plaint in that case, Your Lordship. Because my claim is absolutely against all the respondents, the transaction given on.
If they are praying for deletion of their name, it will be at their risk probably, because you have shown that they are also necessary party. You have impleaded accordingly, and if they are praying for their deletion, it will be at their risk.
If Your Lordship stays,
Now,
Where-
it's
where
not
is-
at stake because there is a clear observation by the trial court. So
no, therefore if I may take, Your Lordship, to one of the order of the Honorable Court, Civil Court himself, Your Lordship.
Mm.
If Your Lordship will come to page number 107, Your Lordship.
yes,
Your Lordship will see 107. This is of 27/6 to 2023, Your Lordship.
yes.
Your Lordship will come. This is the deletion of their name, Your Lordship.
Order in IA.
They filed the IA, Your Lordship, for deleting their names, Your Lordship. Now, if Your Lordship also comes to page number 102. This is when after finally the court started sitting and taking up the cases, Your Lordship. At page number 103, Your Lordship will see 102, why I'm bringing this, Your Lordship. This is when the court started sitting and taking up the cases, Your Lordship. Details of all the High Court's order and when the case was challenged has been reflected in this order, Your Lordship. Now, if I may take Your Lordship to 103, Your Lordship, page number 103. Your Lordship will see the last paragraph. Now, since the instant money suit has been put up after gap of 2 years, the plaintiff is directed to take fresh step to register post. This order is of dated 10th of January 2023, Your Lordship. There was no delay on my part in not pursuing the suit, Your Lordship. And my only prayer for interim with regard to this is, Your Lordship, the grounds on which my IA application was rejected, Your Lordship.
The GD Land Council petition. This is an application under section 115, variation 151 of the Code of Civil Procedure, praying for passing of the improved order dated 9/2/2024, passed in IA number 11, passed by the London Civil Judge, Senior Division. Senior Division,
Bomdila, Your Lordship.
Bomdila, West Coming District, in IA number 11 of 2023, in money suit number 04 of 2016. Records necessary,
Records necessary, Your Lordship.
issue notice, returnable by 4 weeks, for records.
Your Lordship may
It
also
will be a scan copy,
scan copy, Your Lordship.
scan, for the scan copy, the LCR. The petitioner should take steps upon the respondents
If-
by register post with
If
PD.
Your Lordship, if Your Lordship allow me to take dusty service, Your Lordship.
Dusty,
Dusty service,
Bomdila.
Bomdila, Your Lordship. Because this petition I'll have to send through the postal, Your Lordship. It will also take time, Your Lordship. If I may be allowed for dusty, Your Lordship.
Dusty is also allowed.
Yes.
Okay. Then in that case, we have to file affidavit. No?
Yes, after dusty has been filed, will.
The petitioner shall file affidavit. To that effect. List is made after 4 weeks. Sorry, the service we. The service, within a week.
Within a week.
Within a week.
Week.
Or two.
Within dusty service within 2 weeks, Your Lordship. Because I'll have to get the
Okay,
entire
within
record.
2 weeks from today. List is made, then 6 weeks.
After 4 weeks.
4 weeks,
Yes.
is it okay?
Yes, Your Lordship.
Okay, list is made after 4 weeks. The interim prayer shall be considered.
Your Lordship, we've considered the interim prayer today, Your Lordship. Why I'm submitting it? I have also
It
give,
will not harm.
if I have given, because on the next date, Your Lordship, there is a hearing of the IA, Your Lordship.
No, see the observation made by the trial
Yes.
judge,
Yes,
and then I don't see the reason also, because he exercise his discretion. And it's very difficult in these circumstances. Not made out.
but then, Your Lordship, the discretion has to be in as proper
that is-
procedure of law, Your Lordship. The reason given, your lordship will see that
Probably
can-
because
can-
after hearing the parties,
can,
because you took long time, 2016,
no,
and then in the piecemeal manner you have filed.
no, your lordship,
In the-
no, your lordship will see, even in 2000, from, though the petition was filed on, in the year 2006,
Maybe, but
I've
you
also
see-
reflected the fact that it was misplaced, your lordship. Now, there was also, there is also a
Now,
clear,
see the observation of the Learned Trial Court, that for long, say, 6, 7
there-
years.
therefore I have submitted,
2016,
therefore,
2016.
therefore I have given my,
Really not
I
possible.
have given the order of the apex court, your lordship, where it says
Yes,
that
sir, that
delay
consider-
cannot
that
be
is why-
considered while.
That is why, because you have made so much of delay, we'll just give an opportunity. to
And
the
delay
other
was
side.
not on my part, your lordship. The circuit court never said in Bomdila, the circuit court never said in Bomdila, how could the matter be listed?
Now you see,
Because,
you've been to-
because
the-
transfer petition was also filed, your lordship will see, before this honorable court.
You have approached the High Court also more than once.
No, therefore, your lordship, yesterday I have, your lordship, in this petition, I have given my, the withdrawal of the condemnation, your lordship. Why? Because order was passed on 9/2/2023, 24, your lordship. I had filed a certified copy on 12/2/2023, and when was I provided with the copy of the order was on 17th of May 2024, your lordship. Can that be wrong on my part, your lordship? I have immediately applied, and therefore yesterday I have withdrawn the condemnation.
Adversely affect your case in the present case, because IA still is pending.
No,
IA will have to be taken up first.
Your lordship will
And
see,
at the time of
IA,
taking up the IA, probably this would not be touched.
no, why is the IA, why I'm,
Can you consider after the interim period shall be considered?
on the next date, lordship. Deeply.
May I, Lordship?
Yes.
Lordship, this is a joint petition filed by the wife and husband, Lordship. Under section 480 CRP for quashing of FIR, Lordship.
Must move FIR.
Yes, Lordship, which has been registered under section 307 Lordship, IPC. I may straightway take to the FIR, Lordship. That is page 15, Lordship, the FIR.
Yes.
It says, Lord Mayor, to the officer in charge, Women Police Station, Pasigat, East Siang District, dated Pasigat 22nd September 2023. FIR against my husband. Okay. So and so, there is a petition number 2, Lordship. So now regarding attempt of murder and therefore, Madam, with reference to the above cited, I am to inform you that on dated 22 September 2020, around 8:20 hours at Sibo Siang Colony in my residence, while I was sleeping in my room, my husband so and so, that is village so and so, has attempted to kill me by using electric wire to wrap my neck without any valid, resulting which I become unconscious. Later, my neighbor took me to be in GH Pasigat and admitted me for further treatment. When I became conscious, I evacuated in hospital. Therefore, I would like, this is the Lordship FIR. Lodged by,
The offense registered 307.
yes. At that point in time, Lordship, 498 was also lodged, but during the charge sheet, the investigation officer has said she was never assaulted or
Already charged sheeted.
always charged sheeted.
Under which offense?
307, Lordship.
307.
Yes.
So how this can be quashed?
Lordship, this is a joint petition.
So what? You
Even,
attempted, failed,
yes,
and
Lord.
now convinced. How can that be possible?
Lordship, the Honorable Supreme Court in various cases, even 376 is Lordship, was Lordship, taking into consideration that they are wife and husband. Lordship.
Yes.
Yes, your lordship, at least to find out the stage at which the proceeding is, your lordship may call for the scanned copy of the TCR, your lordship.
Lordship,
Because-
Charge considered. Charge.
not consider, Lordship, it's, since it was filed before the Lanet CGM Pasigat, but since seeing,
Let us see the last part.
Lordship, may I take you for
The charge sheet.
49 page, Lordship, this is the last
Page
order, 49.
This is last order.
Yes, Lordship, before the Lanet, oh,
Then have you obtained the charge sheet?
yes,
Give
Lordship,
the charge sheet.
charge sheet, I
Let
have,
us see the last part.
last
Where
part,
is charge sheet?
last,
Charge sheet is page number 28,
Prima facie case against accused.
yes, Lordship.
28, your lordship.
28. Page 20, it's small, just one page, Lordship, the page 29.
29.
Yes, Lordship, this is the, just 2 page, Lordship. It's a dispute between wife and husband, Lordship, married on. Therefore, I am sending the alleged accused, namely George 13, age 29, son of so-and-so, village so-and-so, mentioned before the order. It's not there, no. Or page 28, Lordship,
Says
28 to 8, Lordship. The last paragraph says, under the above fact and circle, in the instant case is submitted into charge sheet via woman PS case number so and so on, dated so and so under section 307 IPC. Earlier it was under 498A, but in their complaint, in 161 statement also, they've stated the husband has never treated her badly, nor
this one. Mr. Yes. Mr. Jamu, V. Jamu,
yes,
Land Council for the petitioner. I've also had Miss V. Ginny, done an additional people, government AP. This is a joint petition filed by the petitioner under section 482 of the Code of Criminal Procedure 1973, praying for crossing of the criminal procedure arising out of FIR dated 22/9/2023, which has been registered as ESG and WPS Women PS case number 25/2023 under section 307 IPC. Where is the case before the court?
before the lauded district and session judge, Lordship, page 49 is the last order.
No, where is the number, case number?
Case numbers are PS
Pasigat
Pasigat
session
session case number 08
of 24.
2024. In the top right, Lordship, under
Case 2.
49, Lordship.
There is, it's not mentioned in the
Case
cause
number-
title.
Case number pending before the court, which court it is pending?
District and session judge.
Where is the number?
It has not been reflected in the cause title. The order,
But-
it's there in the order sheet at page number 49.
Case 49.
Yes.
Just a minute, then. Quashing of the criminal proceedings before the session court. Before the sessions, the session judge, before the court of the session judge, East Siang District Pasigat. Pasigat WPC, no, Pasigat session case, no? Washing of the Pasigat session C number 08/24 pending before the court of the sessions judge, Sessions Division Pasigat, arising out of FIR dated, arising out of the woman PS WPS case number 25/2023 under section 307 IPC. All for the scan copy of the LCR. Issue notice returnable by No, since only the state is party, okay, since Ms. Jenny, then additional PP accepted notice on behalf of the respondent, no formal notice need be issued. List this matter after 4 weeks.
Lordship, I have an interim prayer, since this is in the initial stage, Lordship, even the charge has not been.
I think that will adversely affect you rather, because you can participate or make a prayer before, for discharge.
Lordship,
Or let the charge be framed, and then since you are with, since the main witness, the victim is with you, I think there shouldn't be any problem.
that's why, Lordship, I'm before this honorable court, Lordship, that will be futile exercise of the honorable court time. Lordship, here since we are wife and husband, Lordship, at time of when the bail was granted, Lordship, may I take, when the bail was granted, he was under the, may I take you to Lordship, the page 25, 24, Lordship. Here also, here, they had compromised the way back in 2023. So, Lordship,
The last order, what is the next date fixed for?
it's
CC.
for CC, Lordship. May,
Better you take chance in the CC also during.
Lordship, there is
May discharge.
there is an ingredient, Lordship, there was an act up by the husband against the wife. There is a lot that, since Lordship, that's why I'm before this honorable court, they are wife and husband, Lordship. May I let page 24, Lordship, while granting bail, Lordship, there is an
Now,
order.
see, there is a problem. Because 307, if there is an ingredient, then how do we interpret?
There was an attempt, Lordship, not attempt, what's that,
If it was success, if he was successful, then he failed, that is why he is convinced. He failed.
yet not the Lordship, what is there like,
Now, what is the guarantee that he will not make an attempt?
that is different issue, Lordship. May I take,
Now, you
Lordship?
see, the crime has already been committed.
That is their Lordship, that's why apex court, when in 376 case, where it's a heinous crime, when there's a between wife and husband, Lordship, that can always be compounded by, that can always be caused by the Honorable High Court, Lordship. That's an inherent power, Lordship. May I take, Lordship, while granting bail also, that is the petition number wife was taken into consideration. That is page 23, Lordship. May I take, Lordship? Just small.
Yes.
223, Lordship.
Hmm?
23, 23. When the petition number 2, that is husband was granted bail by the district and session judge. Page 23, Lordship.
Hmm.
That is, Lordship, this is order 2010 of 2023. That is 24.
Let us see the record. Let us see the record.
Lordship, may I just read page 24, Lordship, the paragraph 3, Lordship. It says, Lord, it is not precedent to hear the victim to allow or reject the bail, but since the victim is present, Lordship, that is the petitioner wife, she was heard. She said that she has came to court to support the bail application and has no objection to release the accused on the bail.
These things
That's
have
what-
happened. This happened in all
That-
the different also in some cases.
This is
Vulnerable.
this is husband and wife, Lordship. That's why, Lordship, I have an interim.
Has it been some other case between the husband and wife? But then it's attempt, and if there is an ingredient, it will be difficult. If there is a sufficient material, you see. Yeah. You have annexed the medical document also.
Medical documents, it's there in the charge sheet.
Let us just see.
Page 37, Lordship. Yeah. Is the medical.
Have you annexed a statement of the victim also? 151 statement.
Yes, Lordship, I have annexed. That is in page 31, Lordship. May I read, Lordship? Statement of victim come complaint under section 161 of CRPC. Is on dated 22 September 2023 at around 8 hours in the morning. I was taking rest after having my breakfast. I fell asleep unexpectedly because I was awake last night and attended a program at Bango Solemn celebration, which was held at Sile. While I was in deep sleep in my room, suddenly I felt something was rising up my neck and wrapped my neck by using a rope. When I turned and looked, I saw my husband so himself attempt to kill me. I shouted "Uku" to him, but he was tightening the electric rope more and more around my neck. I was sure of dying slowly. I became unconscious and moveless. Finally, when I woke up and opened my eye, I found myself at hospital on
What
being
is the
admitted.
statement of the accused?
Accused on next page, Lordship, page 32. Statement recording of statement accused under section 1.
Yes.
On being examined, he said that the above mentioned name and so on. On 22nd 9 of 2023, I along with my wife, that is so-and-so petition, visited Sile Oyan Solung Festival. And during evening hour, there was a cultural night program. So we attended it, and during the time a singer was performing, I commented that there was no spark on his performance. At that time, my wife argued with me, telling that I should not behave that way in front of public. And later again, while we were visiting the stall, also she continued arguing with me. She told me that she wants to get separated from me. Every time she just want to put me down. I am never being treated as a husband. And on 23 of 2023, my wife went to sleep, and as we were awake the whole night at the time, just to scare her, just to scare her, I wrapped electric wire on her neck and pulled it, but I did not have any intention to murder her. It was done just to scare her so that she at least respect me in future. Only this much to say. So this is just an Lordship privilege issue between a wife and husband. No doubt the section they have inserted is 307. Earlier 498 was also there, but the investigation officer finding that the husband has never treated her badly or nor has assaulted her before this case.
Okay. In the meantime, as an interim, till the returnable, the proceeding of the further proceeding of the passive accession case is C number 08/2024 shall remain state.
Deeply obliged.
This is matter of.
Lordship has called for the TCR. Your Lordship has directed for calling of the TCR, Your Lordship, from Pasigat. Pasigat, Your Lordship.
Yes,
Deeply.
after 4 hours. Two. Yes.
May I please, madam?
Hmm.
Madam, this is a civil revision petition, madam. While under section 115, read with 227 of the Constitution of India. Basically, here, madam, the petitioner is challenging the impugn order dated 24/5/2023, madam, passed by the learned district judge, Pasigat, madam. Division whereby, my application, IA, interlocutory application seeking condonation of 26 days delay, in filing title appeal against the ex parte Kebang decision. The decision was ex parte. So that has been dismissed, and
Condemnation petition dismissed
condonation application dismissed. That's why I'm challenging that
before the session.
district judge, because ex parte, it happens something like that, just brief facts, just before coming to that, there's a disputed, in respect of disputed land, Dispute is a huge, this mountainous area, The petitioner here, he belongs from this Memba Kamba community, who professes Buddhism, So as per, them, that place is a pilgrimage site, That it's a mountain, it is a pilgrimage site. They believe that this is a abode of some deity of Buddhism, So yearly they visit for pilgrimage purpose. Even from outside the state wall also people visit. So what happened, my lord? Since last so many years, they have been in possession of the land they have been doing. So what happened, well, in 2021 only, some members of the Simong village, my lord, nearby Yingkyung area, my lord, they again started making counterclaim over the land, my lord, saying that this is also their land, my lord. So they go for hunting or doing all those things, my lord. Then dispute arises. Many efforts were made to resolve the thing, could not be done, my lord. So in the meantime, what happened, my lord, very interesting. All of a sudden, someone was served upon the petitioner, my lord. Who is the president of one of the organization which is called, my lord, who is the petitioner here, my lord. It's called Cheme Yangsang Pema Court Welfare Society. This
This
is
is the case between the community.
community. Basically, now, my lord, they have the Gangbura Association has passed the ex parte decision against this society, my lord.
Kambura, which
My lord will find very interesting ex parte decision, my lord. Gangbura village authority has not passed.
petitioner is also not the individual person. It's also
Is the
The
president? It is
president.
the order has been passed against the registered society, and the president here the petitioner is representing as a president, my lord. Because this order, the Kebang order is against this particular society. The society is Chime Yangsang Pema Koda Welfare Society. So then all of a sudden, my lord, this Gangbura Welfare Association, my lord will see Gangbura Welfare Association cannot be said a village authority. It is the Gangbura
village.
Association cannot be, my lord. So here, my lord will see the Gangbura Welfare Association comprising of more than 20 or 30 Gangburas of particular members from Simong village. Not a single Gangbura from our side, my lord, member Kamba community, my lord. They passed a ex parte decision. First,
The association passed ex parte decision.
yes, against this petitioner, Gangbura Welfare Association. But it is basically Gangbura Welfare Association, but they are saying that they are a village authority.
Village under which law?
That's why, my lord. But they are saying that this is a Kebang decision. So I have only the way to appeal against that ex parte decision, my lord. Then I prefer
Anyone XYZ passes any order, will you go for appeal?
no.
If you think that they are not authorized person.
My
to
lord,
decide the case.
but yes, my lord. But what they are doing is that they are exercising the power under this act, my lord. My lord, I will just take the my lord to their
Unauthorized person, can
My-
they act
my lord.
under any act?
My lord, my lord. My lord, no, because law says, my lord, even such order is passed, this is a nullity. This is a nullity. It has no force, it is void of an issue from inception. Because tomorrow that objection can be raised at any stage. Even during the time of execution of the award also, we can always raise that this is not the competent authority to pass the order. That principle of res judicata will not be applicable in such case.
Then falls under,
Land falls under Tuting area,
these Gambaras association belongs to,
Yingkyung area.
not connected with.
Now there is a disputed question. Now they are saying that it falls under my jurisdiction. Then we are saying, well, no, it doesn't fall under your jurisdiction. So many disputed questions are there. So basically, here what happened, my lord, that someone was issued to me. In the not against against the British society. And since I am the president, I wrote a letter seeking the postponement. Someone, my lord, someone, this someone was issued on 28 2022. 28 2022.
Summoned by this
Gangbura Association
to the society.
to the society. Then the Kebang was fixed on 26 8 2022. Then, my lord, on 20, I received the summon on 23 8 2022. I received through WhatsApp. Then immediately on 24 8, I submitted a letter saying that I am undergoing some medical treatment. Kindly refix a date. Then, my lord, despite having received my letter, my lord, 26, ex parte Kebang decision is issued, saying this entire area belongs to the villagers of the Shimong. So, my lord, if I go the validity of the Kebang proceeding there.
Now, who closed the complaint before the Gambura Association?
This is, now I have made them party here, my lord. They are, now my learned friend, she is
They-
representing.
They are independent.
They are
They
the,
are also associations.
yes, yes, yes. Eco Dumbing Forest Development Society. One,
So
and
this, the Gambura Association who has decided are this society, none of these members of this society are the member of the Gambura Association.
no, this complainant are not the members of the Gambura Association. Gambura Association is a bit different.
Okay.
These are only Dumbing Forest Development Society, Simong Himong Community Youth Association. So they file a complaint before the Gambura Welfare Association saying that this is our land.
But the decision says, Father, that this land belongs to them, and then
Yes, ex parte decision,
the ex parte saying what, this land.
declaring ownership in their favor.
Okay, so is there any structure, etc. in that?
Still this one Gompa, because what happened earlier, there was a Gompa that was burned out by the miscreants. So subsequently, we have again established one Gompa. It is still there, one temporary Gompa. That structure is still there. As of today, no one has evicted that part. That is still there. But ownership has been declared by this Gambura Welfare Association.
Here in the.
No, nothing is there. Even no lane area, nothing. Because those things, Your Honor, there are, apart from that, legality, validity of the ex parte decision are there. Because law says, my lord, ex parte decision cannot be given by the village authority. It has to be given in presence of the independent witnesses. Nothing is there. So many things. Those things because definitely this judgment suffers from
You file
appeal before district judge. Because what happened at the time of filing appeal, my lord.
Appeal lies before the district judge.
Yes, why? Yes, as per Arunachal Pradesh Civil Code Act 2021. As per Arunachal Pradesh Civil Code 2021, the appeal lies before the district judge. So I filed the appeal along with the one IA seeking condonation of 26 days, saying that I was undergoing medical treatment as well as my niece. She was undergoing medical. I had to take her to Delhi for medical treatment. I have submitted documents, medical documents. Those documents have been discussed by the learned court also, saying that because of those reasons, 26 days delay occurred.
Was the record called for? Whether the record was called for in this case?
Record was called for, no? I think record is there.
Okay, so, and then, just a minute.
Here, my lord, on two grounds, I am challenging the order, my lord. First ground, my lord, the manner in which way my condonation application has been dismissed, my lord. The learned trial court has taken hyper-technical approach, my lord. In violation of the settled proposition of law, my lord knows that this is not the case of inordinate delay. Had it been the case of inordinate delay, I could have understood that some prejudice might have happened, definitely. But this is the case of 26 days delay also. And this is also not something without explanation, my lord. There is a sufficient explanation, sufficient ground is there, my lord. And the learned trial court has come to the, my lord, has held, my lord, that every day's explanation is required, which is not the law. That is the pedantic approach, my lord. And the Honorable Apex Court in a Ketina decision has said that, my lord, this pedantic and hyper-technical approach has not to be looked into, but substantial justice has to be seen. And that too, my case is, my lord, is the ex parte decision. I never had the chance to contest my case at all, my lord. So in these cases, in this way, discretion has been exercised, my lord. At all, my lord, first, my lord, perverse is there, my lord, irrational is there, my lord, and it is in contrary to the settled proposition of our first ground. The second ground is, my lord, what happened, my lord? My lord, when this application, IA application was taken up, my lord, then the law changed, my lord. This Arunachal Pradesh Civil Code Act, this was amended and notified on 14/11/2022.
Yes.
So before before the final argument took place, my lord. Then under this new amendment act, my lord, now district judge doesn't have jurisdiction.
Now it will be civil judge.
Yes, civil judge senior division or the junior
As per the
division
jurisdiction.
as per the
As per the
pecuniary
jurisdiction.
jurisdiction, my lord.
Then it
Then
will
I
be
raised the
senior
issue.
division.
Yes, madam. And my application was pending there at that time. Then I raised the issue, since by virtue of the change in the law, this matter needs to be transferred to the either to the civil judge senior division or to the civil judge junior division. Well, and interesting what happened here, my lord, that Kebang decision, my lord, it doesn't contain any valuation of the property.
The valuation here in your appeal, have you?
What I did, my lord, in my appeal also, initially no valuation was given. Reason being because there was only one forum only from which I could prefer appeal, because at the time when the appeal was filed, at that time that there was no change in the law. District judge was having the competence.
Since it has changed.
Now since change, thereafter I filed one IA saying that I want to change the valuation of the suit. Thereby I made it the more than 10 lakhs in crores. So automatically senior judge, civil judge will come, my lord. But in Yingkyong there is
Whether have you made an application before this?
not before
In
this.
this? Now I think you have to,
Here,
in the present appeal. also.
no, my lord, not appeal. This is a, my lord, revision, my
So
lord.
revision.
Revision, my lord. This is I am challenging only the order of the district judge whereby my condonation application has been dismissed, my lord. Now I cannot raise the another issue because that application has never been taken into consideration. Now my lord will only see first, my lord, if my lord comes to the conclusion that by virtue of the change in the Arunachal Pradesh Civil Code Act Amendment Act, that the district judge doesn't have the jurisdiction over the subject matter, then definitely this order,
There is, yeah, it is revision petition.
my lord, I have raised that ground, one of the ground. Automatically, my lord, then this order is nullity. This order cannot sustain.
No,
Because-
this order was passed earlier when he had a power.
No,
26.
no, that is the interesting thing.
Okay, when it was passed?
It was passed on, my lord, 24/5/2023. Then the law was changed on 14/11/2023, 22.
So that means he should have transferred this matter. before.
Yes. Either this matter, he should not have taken into consideration at all the IA. If my lord,
Raise this.
yes, I raised.
Where?
My lord, I have made a statement here in my civil petition revision, my lord. And my lord will see, I have enclosed here some document, my lord. Kindly turn to some documents whereby, my lord, in respect of other cases, the learned district judge has transferred all the cases. But my case he has not transferred. And this may be the reason best known to him why my case only is, I have enclosed the order. I will just show.
Enclosed
Yes.
that order.
I will show you. My lord, kindly turn
After
to
transferring rest of the.
rest of the
he has
cases and
taken up this matter.
yes. My lord, kindly turn to page number 157, 161. 157.
Yes.
Yes, my lord. Now these are the all the civil appeal, my lord, and this was transferred. All this I have enclosed this one order.
Page,
Page starts from page 157, my lord.
okay.
Annexure 8 series. 31/1/2023.
So these four orders, the transfer order,
Transfer order, my lord.
are they the one go?
Not in one go, but separately, case wise.
Not by,
Not by one order.
not by making list.
Not by
cases.
making list. Case to case basis.
One by one.
One by one.
Well,
My lord will see 31/1/2023.
once he comes to know that he doesn't have a power, the entire list should have been prepared.
Yes. That would have been the appropriate process, but that was not done. So in my case,
So you are alleging the pick and choose.
no, I will not allege even, my lord. I am just on the point, my lord, when you don't have the authority over the subject matter, your order is null and void. This is one ground. Otherwise, if say, my lord, no, the court has the authority to
Where is
consider,
the statement you have made
my lord.
that all other cases have been transferred except the present one?
All other, my lord, there is no, I have given example that so many other cases.
No, in the averment statement, in the.
My lord will kindly see, Para 7 and 8. Para 7 is about the amendment of the act. Para 7. Then para 8 about
There are
the,
seven
yes, para 7
is the.
about the amendment act. Para 8 is about the,
Act also.
yes, para 8 is about the transfer. The learned district judge Pasighat, in view of the above amendment act, notified on has transferred all the appeals from customary court pending before it to the concerned jurisdictional civil judge. The petitioner has annexed here some copies of the order, some pending appeal, whether it is so and so and so and so.
Just
So-
so, so this was. You file your application. When the Keba decided,
My lord, Keba decision is 26/8/2022.
26,
Yes. 26/8/2022.
22.
Ex parte. I received the order on 10/9/2022. This is the order, my lord. Ex parte decision.
10,
10/9/2022.
22.
Then my limitation period ended at 9/10/2000.
Keba decision page,
My lord will sign Keba decision. My lord will find starts from page number 57, my lord. Page number 57 onwards, annexure 1.
P7.
My lord, onwards, page number onwards, my lord. And of course, this Kebang decision, this Gangura Association decision, this was, my lord, till page 72. 56 Gangura,
57 to.
72.
These are the decision of the Keba.
My lord,
Gangura.
Gangura Association, Gangura Association, page 72 till 72, my lord.
So no judgment.
My lord, 56 Gangura signed the judgment. And my lord, most of them belong to the, my lord, members of this Simon community.
Judgment.
Yes, ma'am. Then my lord will find
They belongs to.
members, my lord, they are the interested party. I would
Interested
rather say interested party, they also belong to the disputing side, my lord, of other side, complainant parties. But basically, my lord, today we are dealing with about the, not on the merit of the Kebang, my lord.
Yes.
Basically, we are dealing about whether my IA could have been considered by the district judge, and if considered, whether this has been disposed in accordance with the law or not. But of course, these facts, my lord, will take into consideration that fact, my lord, that this is a ex parte decision. And this is a plot, my lord, 467 hectares of area, just they want to take without hearing and without giving us any opportunity, my lord. And the learned district judge, my lord, has not condoned even the 26 delays, my lord. So, gross.
You filed, where is your application?
I file my IA, my lord, on
Where is the,
appeal file on 5/11.
where is the statement or environment or the order which says that, shows that you have received the copy of the order on 10/9?
My lord, I will show from my, I think, IA application. IA 128. My lord, page number 131.
Today it is. For Mr.
My lord, this is the only admission. This can be so far, my lord. Only the limited question is there about condonation of delay, my lord. So long hearing is not required, my lord. So this can be disposed, my lord. If my lord thinks, my lord, the district judge has no authority law, then even this application, my lord, it can be retransferred to the competent judge. Thereby, my application can be taken up to get fresh again, my lord.
What do you say? It appears that now on 24/5/23, the district judge, where is the notification? Just a minute, right?
Yes, I will. So this act.
Lordship, sorry, before,
Just a minute.
No, no.
Where is the notification date?
Yes, my lord.
November.
क्या दिया? हाँ,
This was on 14th November
Yes, yes,
22.
yes.
And where is the order in respect of the other cases transferring the same to the
Most of like in January, my lord.
23.
January, yes, yes. After this, after amendment, 31st 1, 2023, 31st 1, 18/2/2023, 18/2/2023. Thereafter, my lord. But now, my lord, all the cases have been transferred. my lord.
Okay, you
Now,
filed,
district-
your application before?
I filed on 5/11/2022. 2022, 5/11/2022, before the
You
amendment.
just take then line wise, huh? Point. Okay. On 26/8/2028. The KBA decided. Ex parte, pass and ex parte order, huh? So, number 2. The ex parte order. The copy of the a certified copy of the ex parte order was received by the petitioner on 10/9/2022. Start. Number 3, petitioner filed a condemnation application before the Lanet District Judge Pasigat on when he filed.
It was filed.
Number 1, the last one, say page 57 of the petition.
62.
Was filed in the month of, it's my lord, 5/11.
5/11. Application filed on 5/11.
Yes, ma'am.
Filed on
IA 77 of 2022.
5/11.
IA as well as civil appeal.
Okay. The petitioner filed condemnation petition as well as civil appeal
Number 105
number 105 on
of 2022 on 5/11/2022.
5/11.
22.
22.
Yes.
22.
Yes.
So where do we find the page?
My lord will find,
The last page,
my appeal, my lord will find, it starts from page number 29, my lord.
29, page 23.
Page 29.
Then, okay, but next one, next.
And my lord, IA, my lord will find page number 128, my lord.
Page IA in page 1.
28, 128 onwards,
28.
annexure 3.
Okay, next number would be the government notified for just a minute. The government notified for amendment of the Arunachal Pradesh Civil Code Act 2021 on
14/11/2022. And my lord will see, there is a one, my lord, provision, my lord, statutory provision written, my lord. Whenever there is a appeal from the Kebang, my lord, appeal cannot be dismissed on ground of technical case. That is written there, my lord.
where
My lord, I can show, my lord. I think I have highlighted there, my lord. The next page, I
for civil civil by which the civil judge is in that last as per the amendment of subsection 3 of section 15. This Court of Civil Judge, senior division of the district. Just a minute. Now, where do we find that the civil judge has a power to take up the matter? As per the act.
My lord will find, this is the amendment 3 proviso, my lord.
Amendment 3.
Proviso, the first.
An appeal against the order of the intervillage.
My lord will find amendment of subsection 3 of section 15.
Hmm.
2.
As per the amendment 3.
Subsection 3 of section 15.
Of subsection 3 of subsection 15. An appeal from the village authority. Shall lie before the Court of Civil Judge, senior division. Okay. Just a minute. Then, where is the transferring of those cases?
Order, my lord.
Yes.
My lord will find transferring order page number 157, 161, annexure 8, my lord.
Next.
157, 161.
One five seven.
Yes.
The district judge, Pasigat, with effect from 31/1/2023.
This is in respect of 4 cases I have collected.
Okay.
Otherwise, there are all the cases have been now transferred.
With effect from 31/1/2023 has transferred all the civil cases to the civil judge, senior division, Pasigat. Except the present case. Okay. Yes.
So now, my lord, on 2 ground, man. First ground, my first ground is, my lord, that the learned district judge has no jurisdiction
Next. Okay.
over the subject matter.
Round.
There is a statutory bar. Since all other cases have been transferred, my cases, including the IA, should have been transferred to the competent jurisdiction. Since there is no valuation of the property, this case should have been transferred to the junior division. Yin Kyung.
Since the round number 1, since there is no valuation and district judge has no power and jurisdiction right after the amendment of the Organization District Court Act. The present, the case of the petition, including the condemnation petition and the appeal, condemnation and the appeal, we file appeal.
Condonation, my lord, condonation as well as appeal should have been transferred there
Appeal should have been transferred
to the jurisdictional.
Okay, and to the civil judge, junior division, along with the other civil cases. Okay. Okay. What is your next player?
Next, my lord. Now, assuming, my lord, if the district judge has a authority to consider. Now, my lord will see.
Delay of how many days you said?
26 days only, my lord. That too, my lord, medical document, air ticket, Delhi, everything I have enclosed, my lord.
Okay.
Then, my lord, the law says, my lord, this amendment act says, my lord, that in case of any such appeal is filed, my lord, before the civil judge or this additional district judge, if any such appeal is filed, such appeal cannot be set aside on technical ground or procedural lapses, my lord. Law says, my lord.
Where do we find?
My lord, the proviso, my lord, second proviso, my lord, of the amendment act which I have given, my lord, is holding in the hand, my lord. Second page, my lord. Second page at that top, my lord.
Yes.
Provided also in case appeal is transferred with or preferred against the judgment of the customary in the court of civil judge junior, the court of civil judge, the court of additional district, or this so and so case, such appeal shall not be set aside merely on technical ground or procedural lapses, but in the interest of justice shall be disposed of as may be deemed appropriate or proceed with case de novo. My lord, why this provision has been given is, my lord, basically, my lord, in the Kebang proceeding, my lord knows, basically, my lord, there is nothing, my lord, they don't maintain any record or anything, my lord. Basically, Kebang proceeding is understood, my lord, if the parties, they mutually, amicably resolve the issue, my lord, then it is good, my lord. Otherwise, my lord, there is nothing like, my lord, record is maintained, evidence is standard, nothing is, no pleadings is there, my lord. So basically, my lord, on the ground of, my lord, my delay is, my lord, is saying, my lord, I've said that there is a sufficient ground. Only on that ground, that to a ex parte decision, my lord, that my condonation application should have been allowed, my lord. Then matters should have been taken on merit, my lord, and I should have been allowed to contest the case, my lord. Now, my lord, let's see the order, my lord. The order, my lord.
Amendment of subsection 3 of amendment of section 3 of subsection 3 of section 15. Provided this. These two. Okay, yes.
My lord may I tell, my lord, let's now come to the, my lord, impugn order, my lord. I will just highlight, my lord, what are the, my lord, apparent
Page.
error, my lord. It starts from page number 20, my lord. The impugn order, my lord.
Yes.
My lord,
Page 20.
20, it starts from page 20 onwards, annexure 1. Now, my lord, I will take to 21, my lord.
Yes.
Second paragraph, my lord. Now, learned district judge has himself recorded here. The appeal has been preferred in terms of Act 2021, and the same has been amended in the month of November 2022. However, the parties have submitted their arguments before this court. Now, my lord, I will pause here. Now, learned district judge is fully aware that there is a bar. There is a. Now, let's assume learned district judge is saying that as if I did not make any objection. Let's assume that I did not make any objection even. But the law says, my lord, that even the parties doesn't make objection. No power when there is a bar. This is not the, because, my lord, jurisdictional aspect, 3 jurisdictionals are there, kinds of jurisdiction. So for territorial and pecuniary jurisdiction is concerned, I can waive that part. Suppose court is competent, but no territorial jurisdiction. If court is competent, no pecuniary, then, my lord, if I have not raised the issue, I cannot raise. But this is the jurisdiction of the subject matter. I will show the judgment, my lord. The judgment says, my lord, whenever there is a, my lord, jurisdictional competency, my lord.
Yes.
So lack of jurisdiction in the case of subject matter, the decision says, my lord, such judgment is a nullity. It's void ab initio. No amount of my acceptance, parties cannot confer jurisdiction against the state. So, my lord, the learned trial court ought to have considered that since doesn't have jurisdiction, even assuming I did not raise the objection, he ought to have transferred this matter, my lord. Not done in this case. Now, my lord, next part, my lord. Now,
in the impugn order
Yes.
at page 21. The learned the learned district judge passed on made an observation. No, stated that under inverted comma, the appeal has been preferred in terms of APCC Act 2021, comma, 2021. And the same has been amended in the month of November 2022. However, the parties have submitted their argument before this court. Okay.
My lord, kindly turn to now page number 24, my lord. Page number 24. I will page 24. I'll just highlight, my lord, what are the infirmities in the orders, my lord. Now, page number 24, my lord, at the bottom, my lord.
Page 24.
The last 24, my lord.
Yes.
Last paragraph. It is admitted by the applicant that he got the copy of the impugn order on dated 10/9/2022. It is established law that the period of limitation is always calculated from the date of the decision or judgment as such. The limitation shall be run from the period of 27 August to 26 September 2000. However, by the next page, however, the applicant has right to deduct the period spent to obtain the copy of decision in terms of section 12 of the Limitation Act. Thus, the period from 27 August to 10 September is condoned or deducted in terms of referred above, my lord. Now, my lord, this part is very important, my lord. Now, here, learned trial judge is saying that period from 27 August to 10 September, that has been condoned, my lord. Now, my lord now will find, in the now just contrary to that one, another contrary observation will be made, my lord, because first learned trial court is saying this period 26 August to 10 has been condoned. That has been condoned, my lord.
That is automatic.
Automatic. Now, my lord will see.
Otherwise-
Kindly turn to my lord last paragraph here also.
Yes.
Now, my application has been rejected on the basis said that I have not given explanation for this 27 to 10 September. 10 September to 9 October.
No, which, where?
Now,
Last.
10 to October, the last period 32 is complete. Now, my lord, will find this para 26. Para 26. Page 26, last paragraph. Therefore, the period from 30 September to 9 October, a period of 10 days is completely dark or silent or unexplained. But that days have already been condoned.
Yes.
Now he's saying that I have not explained that one. In the meantime, the period of limitation ended on 9 October. So, my lord, when limitation on 9 October, thus the explanation or medical ground from 23rd October to 30 has no meaning at all without proper explanation from the period of 30 September to 9 October. Now, my lord, I pause here for a while. When the period of 30 September to 9 October has already been condoned, my lord, do I require to make any explanation? Because at that point of time,
No. He condoned from 27 August to 10 September. 27 August 22 to 10.
9th October, my lord. My lord, period of started on 10 September. 10th September.
Yes, starts from 10 September.
10 September.
Up to 10 September is condoned.
Up to 10
September.
is
27
condoned.
August to 10 September is condoned. At page 25.
Yes.
And but 30 September to 9 October is the
30 September to 9 October. 30 September to
10 days.
no, my lord. Here what will happen? Let's come to page, my lord. 10 September is condoned. Thereafter, my lord, page 25. Now, therefore, period of limitation is started to run from 10 September
Okay, again from 10.
and on 9th October. No, till 9th October, there cannot be any bar on me, man. The delay period will start only after 10th October, man. So I don't need to make any explanation so far September is concerned. Now, what I need to make is the explanation above 10th October, man. My lord, if I am clear, my lord, on this point.
Now therefore, the period of limitation started to run from 10th September
My lord.
and ended on
9th October.
October.
Means 1 month period I get for filing appeal, man.
Hmm.
So delay starts from 10th October.
Yes.
Now, but
So this is 1 month period.
yes, man. But my application has been rejected, saying that from 30 September to 10 October, I have not explained.
Well,
My lord, page 27. Page 27, my lord.
hmm.
In the meantime, the period limitation ended on 9 October. Thus,
In
the
the
ex
meantime,
in the meantime, the period of limitation ended on 9th October.
where do we find?
My lord, page 27, my lord.
Okay.
On the top, my lord.
In the meantime, the period of limitation ended on 9th.
October. Thus, the explanation on medical ground from 23rd October to 30 October has no meaning at all without proper explanation from the period of 30 September to 9 October.
Just a minute. At para,
My lord.
at page 25. The Land Court observed that the period from 27 August, 27/8 to 10, 27/8/22 to 10/9/22 is condoned or deducted in terms of the referred period. Start. The period of limitation started to run from 10/9/2022 and ended on 9/10/2022. He said that the period of limitation started to run
My
from
lord.
10th.
From 10th October. And my lord, it ended on 10th October, my lord.
9th, ended on 9th October.
9th October.
However, next para, page 26. The line of code again observed that period from 39/2022 to 9/10/2022, a period of 10 days is completely dark or silent or unexplained. Start. Where you say that,
My lord, then my explanation, my lord. My lord, kindly turn to page number 132. My explanation
No,
in the
where here is, in the meantime, the period of limitation ended on 9th October. Thus, the explained on medical ground and there's no meaning. Without proper explanation from the period from 13th September to 30th. Okay.
my lord, here page 25 itself, my lord.
Hmm.
The statement, my lord, that the wrong principle of law has been applied here. it is also a settled principle of law that every movement of the delay period must be explained properly by the applicant, madam. Well, this is not the law. How
Where are you reading?
Well, page 25, madam. Of the impugned judgment, madam. Page 25.
Yes.
25. Now, reasoning, my lord.
Hmm.
Last paragraph.
Hmm.
It is also settled principle of law that every movement of the delay period must be explained properly by the applicant. However, in the present case, the explanation on medical ground is not supported by any documents or any specific averment from the period of 10th September to 9 October for treatment at Itanagar and treatment of his niece at Guwahati. The travel period of applicant with his niece is shown from the period of 24 October to 30 October, whereas by that the period has already been expired for a 15 days period, madam. Now, my lord has seen this principle of law. Every movement of the delay, my lord, there is no such law. This is completely contrary to the settled principle of law, my lord. The court, my lord, repeatedly has been saying, my lord, that liberal and pedantic approach has to be taken, my lord, when their substantial justice is concerned, my lord. And unless there is not an inordinate delay, my lord. This is not the case of inordinate delay. Or I have a sufficient cause, my lord, I have shown, my lord, that during that period, my lord, I have enclosed medical document also, my lord, that I was also undergoing treatment at RK Mission. My niece was undergoing treatment at Guwahati. Thereafter, she had to be taken to Delhi. All those documents are there, my lord. Now, the learned trial court has taken into consideration some of the medical document of the Delhi, my lord, and the flight ticket. Now, they're saying that 15 days has not been explained, my lord.
Okay. Okay. So what else?
My lord, my lord. Then, my lord, no, my lord, medical document, my lord, may I show, my lord?
It's okay.
Okay, my lord. Then, my lord, will see.
Medical document annexure?
My lord, I have annex, my lord. Flight tickets, everything I have annexed.
Medical document annexure page?
Medical document, my lord, starts from page number 135 onwards, my lord.
135 to
135 to 140, 140, 148 till, my lord, including flight ticket, my lord.
page 140. Including
Flight tickets.
Okay.
Now, my
Anything
lord,
else?
law, just, my lord, I will submit some judgment, my lord. Just to show the
Okay.
principle. I won't make some argument, my lord.
Yes. Yes.
So just principle of law, my lord. This 1987 to SCC, my lord.
Okay. This is regarding?
Regarding, my lord, certain, my lord, guidelines has been framed by the Honorable Apex Court, saying, my lord, that delay, my lord, this everyday days delay need not be required to explain, my lord. Liberal approach has to be taken into.
Okay.
I have already. Para, my lord, 3. Then, my lord, 2001. Para 5. I have explained what is inordinate delay.
Para 3.
Para 5. Earlier, para 3, my lord.
This is regarding inordinate. Huh?
This is 2001 regarding inordinate delay.
Inordinate 2001.
Yes, my lord. Para single para 5 only.
Para 5.
Para 5, my lord. Then, my lord,
Para 3 of this 87 is regarding?
Para 3 regarding, my lord, the principle governing how the delay application has to be considered, my lord. And pedantic approach should not be taken, my lord. There is no requirement of explaining every day's delay, my lord. Reasonable, my lord, human approach should be there, my lord. If, my lord, somebody is suffering, my lord, from Delhi, I am taking some patient. How can I leave my patient and immediately I go and file the case, my lord? This is
Where is the citation which says that if the judge doesn't have a power
my lord.
without jurisdiction, he can.
I am giving, my lord. That part, my lord, 2005, 7 SCC, 791. I have
Citation book here.
2005. 7 SCC. Page number 791.
2000? You have
2000. My lord, I will give.
You have the copy?
Yes, I
Copy
have.
book.
Okay.
Okay.
2005.
1980. Next one. 1987, 2 SCC 107, para 3. And then para 3 regarding principal governing the how delay application is to be considered. Then next para 2001, 9 SCC 106. Para 5 regarding inordinate delay. Okay,
Then 2005, 7 SCC,
2005, 7 SCC,
791.
791, para
There are 30, 31, 32, 33.
30, 31,
32, 33. This is regarding, my lord, lack of jurisdiction over the subject matter.
2005.
Statutory
7
jurisdiction.
SCC. Yes, 7 SCC, 791, para 30, 31, 32,
33, my lord.
33 regarding lack of jurisdiction.
My lord,
Okay. Anything else?
my lord, two more judgment from our own Honorable High Court only, my lord. Just to show, my lord, that our approach also has been very liberal, my lord, unless it is very inordinate delay, my lord. Just to show that one. In medical ground, more than 200 delays have been condoned only because medical document was submitted and principle was discussed, my lord. So, just for reference only, my lord. With this, my lord, para this 2022 SCC online Guwahati 2249, para 8, 9, 10, my lord. This talks about how approach should be there while considering the application. And another, my lord, para 15. There was a delay of 120 days. My case is only 26 days. And even 15 days explained. Now, my lord, with this, my lord, I just conclude my argument, my lord. My lord, if my lord is satisfied that the district judge doesn't have jurisdiction to consider, then my lord, matter should have been transferred. Then my lord may be pleased to pass the order, setting aside the order, transferring the civil appeal as well.
Let us see your prayer. Have you made that prayer?
My prayer, my lord, will find.
Page 17.
Setting aside is there, my lord.
Yes.
And I have sought prayer, my lord, to allow my condonation application, my lord. Thereafter, my lord, after allowing my condonation application, direct the district judge to transfer. I have mentioned here civil judge Pasigat Senior Division, my lord. This can be decided by the district judge whether it should be transferred to the senior division or to the junior division Yingkyong, my lord. That can be done.
Yes. Yes.
May I please, Your Lordship?
Yes.
I will first come to the issue of jurisdiction, Lordship.
What do you say about this? Yes.
Yes. The civil judge senior division, as per this amendment only, the civil judge senior division has jurisdiction in the district in which it is situated, or more district as per any notification. Now this case relates to Upper Siang district and not East Siang district. Your Lordship will see at page 157 one order of the civil judge, of the district judge, in which the cases were transferred. Here also is specifically mentioned that the appeal from village authority shall only lie to the court of additional district judge or district judge. 157. This is a series of orders in which cases the appeals were transferred to the respective civil judges. This is one such order. In the middle portion, Your Lordship will see the appeal from village authority shall lie only to the court of additional district judge or district judge where there is no establishment of civil judge senior, junior senior division. Henceforth, appeal from village authority of village authority or customary court shall lie to the civil judge senior division, civil judge junior division. In the absence of such court, appeal lies to the additional district judge or district judge. Now he has filed
He quoted which provision?
this amendment, Lordship, 14 November 22, which my learned friend has also placed.
Where did he find that?
That is in the second para.
Second para.
Yes, citing this only, he has in the second para of the same page, Lordship, 157.
Oh, no. In the act,
In the act, Lordship,
yes.
yes, in the act, it is the amendment of subsection 3 of section 15. In the amendment act, it is in the serial number 3.
Yes.
In the principal act, in subsection 3 of section 15, after the words Court of Civil Judge Senior Division of the district appearing in the last part of the sentence, the words and in the Court of the Civil Judge Senior Division has, and in case the Court of Civil Judge Senior Division has not been established in the district, to the Court of Additional District Judge or the District Judge as the case may be. So in cases where there is no Civil Judge Senior Division, it should be read as to the district, to the Court of Additional District Judge or a District Judge as the case may be.
Is there any notification
Lordship?
that the coverage of the civil judge senior division of the Pasigat?
Lordship,
That is the practice.
that
That
I
is the- think
don't
generally
know
that
of
is the
any.
practice. I think senior division is taking up the case of the valuation which is more than 10 lakhs.
I do not know of any such notification, Lordship, because of that, the appeal, in the absence of a senior judge, civil judge senior division, should lie before the district judge. Then Lordship will see, provided further, in the second proviso of subsection 3 of section 15 of the existing entries, the following shall be substituted, provided further, the amendment, Lordship. Amendment that 14 November 22, which my learned friend has given this honorable court.
Which provision?
The same, Lordship, 3 subclause 2.
Yes.
In the second proviso of subsection 3 of section 15, for the existing entries, the following shall be substituted, provided further that in the case the Deputy Commissioner could not dispose of the pending appeals in their courts within 1 year from the date of commencement of the Arunachal Pradesh Civil Courts Act 2021. They shall transfer such pending appeal cases to the courts of Civil Judge Junior Division, the courts of Civil Judge Senior Division, and the courts of Additional Judge or the courts of District Judge as the case may be, as per their territorial and pecuniary jurisdiction. So this is qualified by as per their territorial and pecuniary jurisdiction. Now the territorial jurisdiction we cannot say because there is no Civil Judge Senior Division in the district of Upper Siang. So that is the reason why in that order which I have shown that that was also made, that mention was also made. Also, there is one very pertinent thing which your lordship may take note. They have filed an IA during the pendency of the appeal, during the pendency of that proceeding before the district judge, saying they want to amend the cost title so as to increase the valuation of the suit, which amounted to some crores, lordship. So if they say, because they're saying two things, that the valuation should have been much more, the valuation was not mentioned for some reason, for whatever reasons that they know. If the valuation is of such amount as they have quoted, then the pecuniary jurisdiction would lie before the Civil Judge Senior Division, which in this case is absent. In the absence of the Senior Judge,
I think we need to find out.
yes,
There is, because is it the case where, say for example, in Pasigat, in this East Siang, there is Civil Judge Senior Division.
yes.
also.
Pasigat,
But
my
then
lord, senior division
there
is there.
are
Junior division is not there. In Pasigat,
Pasigat Junior Division.
not there.
Yes, exactly. And then in the
And
case,
Yingkyong, see, junior division is there.
Hmm.
And because my lord, it is something like that,
no, this Pasigat,
under Pasigat division,
under this.
under Pasigat division, only one
Pasigat division.
civil just senior division,
So
one
he
is
the
there,
one
who is stationed
take
at
up the-
Pasigat.
He used to take up the cases tribal by the Senior Judge Civil Division
Of other
of the
districts.
the jurisdictional
That
This is
particular
also-
notification I have also not come out. I have not find out.
Whether the civil judge senior division is taking up the cases of the other district.
My lord, I can, that's why, my lord, now, my lord, I will pray, my lord, let's forget about senior division.
Hmm.
Because my learned friend has said that in the IA, I have asked for, my lord, changing of the valuation, but since my IA has not been taken, my lord, no, there is nothing in the IA, no valuation in the, let this matter go to the Yingkyong. Let this matter go to Yingkyong, my lord. Then thereafter,
The jurisdiction fall under Yingkyong.
Yingkyong. Let this matter go to the junior division Yingkyong, my lord. There, my lord, once my IA is considered, appeal is admitted, thereafter, if I require any amendment is to be made, my lord,
Okay.
then I can go for it. Now, my lord, my application has not
Okay.
been considered.
Then in that case, my lord, if what he is praying for, in that case, no observation on merit should be made regarding the IA, regarding this order. Only on the part of jurisdiction, this case may be disposed of. Because,
Apparently, district judge did not have.
yes, yes, only that part. This honorable court may not make any observation so far as whether or not that condonation of delay, acceptance or not was right or wrong. Only that part. Yes.
My pray.
Mr.
Because there is of no use if they say that the
Direct counsel for the. I've also heard Miss N. Dungan, direct counsel for the respondent. We'll pass over. I'll pass over. Other matters are also.
Deeply obliged.
oblige.
Yes, other matters. Yes.
Hello, this is also the joint application filed by the spouse. Praying for quashing of the drinking PS case number 5, wherein my lord the case was registered under section 452, 336, 323, and the 324, 506 of the IPC. What had happened on the, my lord, the incident
What's the
to
petition?
Washington? Incident took place on my lord 24/11/2000.
36 also.
My lord. Now, my lord, the facts behind these cases, my lord, the incident took place on 24/11/2023. My lord, both we are the petitioners are, my lord, the, out of our wedlock, we have one son who is hardly 7 years old now. So board of contention is pertaining to the maintenance of the son. Therefore, my lord, we have frequently meeting and discussion, and out of that discussion, my lord,
Just a minute. Let us just see once the FIR.
my, my lord, kindly come, FIR is on 14.
Hmm?
For the,
11A.
my lord, the 11 and my lord, 11 that I about copy. Would, my lord, got it. With due grievances, I am to inform you that my ex-husband, Sri Oni Ali, is petitioner number 1. Town of such and such of the POPS Jengi come to my residence at around 7:30 p.m. on the November 2023, and he physically assaulted me and tried to attack me on my neck by the dog. When I tried to call for the help, he threatened to kill me and set my house on fire, and along with the 12 years old, escaped and went to my government quarter at the Jengi. Later on at 8 p.m., he set the house on fire and everything was floated down on the ashes. Nothing was recovered. The witnesses to the incident, and the accused person assaulted later on. That witness is my lord is speaking about the he was she was assaulted, my lord, the petitioner number 2 was assaulted. Note that the petitioner number 1 has said house to the fire. This morning on 24 November 2000, the accused again come in the residence and warned and threatened me with the sisters minimum pankam window. Father, I would like to inform you that,
What is the status of the case at the moment?
my lord, so far the status of the case is, my lord, the charge sheet has filed, but the so far trial is yet to start. Trial has not
This is
started.
not yet done.
No, my,
Charge not yet considered.
yes.
So it is at
So-
the stage of framing of charges.
So in due course of time, my lord, what I am trying to point out, my lord,
436 is also there. It is difficult whether the report has been called for here in this case.
my lord, the matter has been intervened by the village authority.
But 436 is also there.
My lord, whatsoever, my lord, the section is there, my lord.
Hmm?
So far, my lord, the 437 or 436 is concerned, my lord. Allegation is there, but what exactly what happened that after quarrel?
Whether the report was called for here in this case.
Yes, my lord,
Record need to be seen.
record should be,
The
my lord.
statement of this victim and other witnesses. Because it appears that from the place of the fire, it appears that there were other witnesses also. Record not in court or what?
My lord, so far I remember record should,
Record-
my lord, record was
Record
called.
would be needed here in this case. In order to consider the case. Without record, it will be difficult to adjudicate the case. But the record was called for now.
Lordship, first, on the first occasion, Lordship, record may be called for Lordship. If it,
Mr. C. Modi, Land Council for the petitioner. Also have Mustafa, also Ms. Additional PP for the state of Bihar. In the instant case, the court of the trial court would be necessary. Charge it already filed.
My lord.
Okay. Charge it, it would be necessary. Accordingly, let the scanned copy of the NCR record.
And my lord, since the charge sheet has already filed, I may be called from the court at any time. Therefore, my lord, the further proceeding be statement, till a record come. In connection with the Janging PS case number 5.
Is it tribal by this tribal by session?
Yes, my lord,
36 was the session.
my lord, that 436 will be session.
Whether the case has been committed to the session.
My lord, no, so far no.
Not yet.
Not
Then I
yet,
think
my
there's
lord.
a time. Have you mentioned the case number? Yeah.
No, my lord, because other than my lord, that I have received the charge sheet and thereafter, my lord, so far case record has not been, my lord, traced. Since, my lord, the trial yet to start and I have not been intimated.
Which court?
This is of my lord, this should be of my lord, Janging PS case number 5. And the forward, same has been forwarded to the JMFC Inkyong, my
It
lord.
goes where? Yingkyong.
Yes, my lord, JMFC Inkyong. Judicial Magistrate First Class.
Why not? Where the
Lordship.
case is? Then where do we have the record? From where do the record need to be called for? If it is has been already committed, then it will be available at
Lordship,
Pasigat.
Lordship. But it's a session court or Lordship, JMFC Lordship, because,
Obtain instruction
Lordship.
whether the case has
Because-
been already committed in the session court or not. Then
Lordship.
thereafter will direct.
Lordship,
Because number is also not given, because the case will just after filing charge sheet only, he has filed this application, isn't it?
My lord.
Then instruction first,
Lordship.
then
Lordship.
otherwise where do the notice?
We'll obtain instruction from the IO Lordship, then investigation officer Lordship, where they have submitted Lordship from the IO.
Yes, then thereafter you have to ask
Lordship. Yes, Lordship.
in the concerned court whether the case has been already committed to the
Lordship.
session court or not. Because 436 probably is tribal by the case.
Yes, Lordship.
Okay, just before that, the case, the learning counsel for the petition submits that when Mr. C. Modi submits that the case has already been charged sheeted. However, he has no idea whether the case has already been committed to the session court or not. In view of the direct petitioner PP, Ms. Al Hage shall obtain instruction.
I'm checking PS, Lordship then. I'm checking PS.
Ranking PS, and
Lordship.
then because they have already submitted charge sheet.
Lordship, I have no idea, Lordship, whether,
Now,
Lordship.
now, in Kyong, you have to ask from the staff of the Kyong whether this case, the FIR number is there, whether this case has been, since the case has been filed in the charge sheet, whether the case has already been committed to the session judge.
Lordship,
Then if it is still there, then we'll have to call a record from there.
Lordship.
Obtain instruction regarding obtain instruction whether the case has as to whether the case has already been committed before the session court or not. Least as matter after 2 weeks. Yes.
Apply.
23. Okay. Hmm.
23.
Yes.
My lord, this matter may be fixed for day after tomorrow. Fixed for day after tomorrow. Yes. And moreover, I may be allowed to correct some clerical mistake in ground number 4. I may be allowed to get corrected in my petition, in my appeal petition. Mistakenly, clericals here
Mr.
are
Mr.
for T. Torum.
T.
Torum.
Your name is not there. Torup, sorry.
There.
Okay.
T. Torum.
I will counsel for the appellant. Praise. Submits that there is some error in where?
Ground number 4,
Error.
page number 11.
Round number 4. What is the date?
Some clerical mistake, some
There is
other
clerical
point is,
mistake.
yes, that may be get
In-
corrected.
Round number 4 of the petition, and praise for allowing him to correct the say the prayer is allowed.
Kindly fix for day after tomorrow.
List is matter.
Day after tomorrow.
Day after tomorrow is Friday.
Yes.
Probably Monday.
Then Monday we have, then tomorrow. My lord, kindly tomorrow. May
Tomorrow
fix
is already prepared.
day after,
Okay, day after
any
tomorrow.
day after tomorrow. Much obliged.
Day after tomorrow is date 21. Okay, next. Four. Okay,
My lord, item number 4 and 8 can be taken up together. 4 and 8.
4 and 8.
My lord, in this case, the complainant has filed an affidavit objecting the bail application. Now, my lord, he wished to appear in person before my lord. So telephonically, he has informed for some accommodation, my lord. So for one,
Okay. Director of personal appearance.
yes, not personal appearance. He wished to appear as in person before this honorable court as
Okay,
a
okay,
complainant.
listener.
Yes, my lord.
Complainant. I am
Complainant, complainant. my lord.
Okay.
The complainant has filed an affidavit objecting the bail application
Okay.
filed by the petitioner. my lord. Now,
So when
he is seeking some accommodation. my-
For 25, madam.
is prayed for by the land council for the parties. List is matter on 25.
25 and 5 June.
Okay, 4 and 8, huh? Item 4 and
Well,
8.
interim is there, that may be.
The interim order passed earlier, shall continue till then. Okay. Yes.
My lord, in this case, on the last occasion, a case diary was called for. But however, we have received a WT message stating that the concerned IO is out of station. So therefore seeking some more time to produce the case diary. my lord.
So,
But just in a lighter vein, let me explain in 1 minute about this case, although the situation has come. But what will happen? Purportedly, the arrest has been caused because of monetary transactions with alleged PIM. And nobody was arrested from the place of occurrence. Well, see, therefore, well, we'll also have that apprehension in the mind. All of us have to deactivate our online transactions. As in the Katina, in many of the cases, I have also made an open submission in many of the courts that these special cases, laws, they are at all not a gender neutral. Section 30, is a reverse burden. All those kind of things, only on the sole basis of a transaction, online transactions.
so what is on, to be fixed on
27/6/2024,
26,
as
and,
read by the IO, my lord, 26.
But 26, the matter may be fixed on 26, and in item 5,
Mr. Titi, I'm also for that. It is approved.
Huh.
I'm also for Mr.
J. Singh. J. Singh.
This is planning PP. Who submits that? That's all. Are you?
Why is he out of state?
Okay, who submit that the IO of the case is out of station out of station at Assam on duty, due to which the case diary could not be produced. And then, according to paper, he has paper listing this matter on 27/6/2024.
26, 26.
26.
26.
So far, the IO has played on 27, my lord.
27.
Yeah.
This is dilatory practice.
No, no.
The conduct of
One
IO
day.
in
If
this.
he is coming on 26
Yes.
and wanted this matter to be fixed on 27, no point, I think, fixing on 26. So, no, 27.
Then this in item number 5,
Let's pray
Uh,
for list this matter on 27.
Item number 5, I may be allowed to take steps through the office of the
And,
party.
Item 7.
5.
Item 5.
5, I think, taken. 6 or 7.
5.
6 or 5.
Item 5.
6, 7. So already done. This problem is because of that Jagjit Singh judgment. Jagjit Singh judgment is out of blue. On a base jurisdiction, violating the main objective of the
Item-
statute. Item 5.
Item 5.
Maybe steps may be allowed taken through the office of public prosecutor.
Yes.
That's why I was saying, because of this particular judgment, Jagjit Singh, it was on a bail jurisdiction, and then overriding the objective of the statute, suddenly this law came into only giving a participatory right. And now my lord is aware that section 301 of the IPC is there, CRPC is there. Even if they are made party, my lord, whatsoever it may be, they hardly have any right to make any submissions, except or otherwise to assess the people. This Jagjit Singh judgment, my lord, is a bad law.
Yes, ma'am.
Yes. Correct.
Okay. Okay. Mr. Counsel for the petition. Mr. Counsel for the petition. Impleaded, not yet.
They have impleaded respondent number 2, but
Who is
they
there?
shall
But
take a
the-
step.
For the victim.
They have made-
because according to after that Deepak Naik judgment by our division bench,
Okay.
then there is a notification number 15, which says that it is there, no? C2 guardian, my lord. Now here in this case, here in this, my lord,
Yes, step be taken
within 2 days through the office of PP, my lord,
within.
in terms of the
through
notification,
office.
right?
And this will be fixed on
27, okay. my lord.
Same,
27, will
same
it be
day.
done, huh?
Same day. If they can take the steps within that period.
Okay.
The predicament,
List is better on 27.
The-
Let's pray for the counsel for
the
the-
predicament of accused in jail, my lord.
Obligement.
Six.
My please, Lordship,
Seven also.
my lord, Lordship, in this bail application.
24.
Yes, my lord. In this, what happened, my lord, after filing of the bail application, the mandatory periods is over, my lord.
Okay.
So on that account, we have filed this IA 56, my lord. Therefore, Lordship, but the accused was arrested on, my lord, 9/4/2024, my lord. So now 60 days is over, my lord. On
Yes,
that,
who is- Okay, Mr. Peter, Council.
your Lordship has already passed order in another matter, same case actually.
Okay,
Then-
I've also heard this. Council. And then it's like two people for the state of. Stuff. This is an application. Then I'll pass order.
Yes, my lord. This, your Lordship has already dictated similar order only.
Right.
Not same, but similar order, my lord. Then bail was filed, then mandatory period was over, your Lordship.
When
He was arrested on 9/4/2024, my lord.
this is bail application filed under section 439 CRPC, claim for release of the accused. What is the name of the accused?
My lord, Priti Ponung Moyong, my lord.
Mrs. Ponung.
Yes.
Who has been arrested in connection with the Nahalganj police station case number 31/2024 under section 21B, 27, 29 of NDPS Act
Yes.
1985.
Yes.
The case of the petition is that the accused was arrested on
9/4/2024.
9/4/2024
2024.
in connection with the NDPS case.
Nine-six mandatory period was over.
Okay. However, during the pendency of this
Bail application.
bail application, the accused has completed sorry, during the pendency of this bail application. The accused has already spent how many days?
More than 60 days, ma'am.
More than 60 days. That is
Yes.
more than 60 days.
Now, today it will be 70 days. 60 days is sufficient, more than 60.
That is beyond the mandatory period of 60 days. How the police has failed to find charges into the case if they under the circumstances. The accused is entitled to be released and consider for his her release on bail under the provision of section 167 to A of the CRPC. That there will be some condition.
Yes, ma'am.
condition.
Normal condition, Lordship.
So what is the fine?
Mala?
This is 21B,
Yes. Intermediate, Mala.
intermediate.
Yes, Lordship.
Her husband is also involved or something like this? Is
Yes,
that
yes,
the case?
Lordship. But no possession, nothing was recovered from them. It was from third party, ma'am.
Okay.
It was said that they were involved in.
Rest are-
Lordship, Lordship,
Some other-
TP, Lordship, T. name should be reflected because she was T. Because she was
Yes,
handling
yeah.
this matter and she was for some urgent work, she is.
Yesterday we have passed.
Yes,
Yes,
Mala.
ma'am.
She was there, Mala. She admitted. Not charged.
Huh? Yes,
Obliged, ma'am.
this is item
24.
24.
Yes.
Okay.
Obligement.
If I. Then.
Please, Lordship.
Yes.
My lord, this is a matter in which the marriage was solemnized in Guwahati. The boy's family, the husband's family, they stay in Gurgaon, Haryana. The girl's family
It
is
is solemnized at Guwahati.
Guwahati.
Okay.
Girl is from, this was in November 21. Girl is from Chhattisgarh. Boy is from Haryana.
Okay.
Marriage was solemnized, only thing, marriage was solemnized in Guwahati. Now, marriage, what happened? They didn't get along well. They did not get along well. There was demand of dowry, abuses, everything from the husband's side. So the wife left his company. Wife went to Chhattisgarh. And when the things, they tried mediation, but mediation failed twice or thrice. So wife lodged an FIR in Chhattisgarh, Raipur, that is the capital of Chhattisgarh. She lodged an FIR under section 490A. She filed a petition for divorce. And she filed a petition case under Domestic Violence Act. Now, dates would be important, my lords. November 21 was the marriage. They stayed for some time together, then they separated. Girl went to her parents, boy stayed at, then May 22, the boy went to Canada and he had some illicit relationship, live-in relationship with some other girl. He stayed there. So the disputes continued. Then, my lord, what happened is, 28/11 is the complaint filed by the girl before the police station at Raipur, at Chhattisgarh. November 22.
Complaint filed by?
By the girl, by the wife.
Where?
In Chhattisgarh, where she stayed.
Apart from this 198 and the divorce.
Pardon me? No, same. I'm coming to the date.
Okay.
The same 498A matter was filed in Raipur in November. And January, my lord, 4th of January, the police at Raipur registered a case under section 498A and 34 of IPC against the husband and his mother and father.
No. Complaint was filed before?
It was, my lord, at the police station, Raipur police station.
Raipur, where?
Raipur is Chhattisgarh. It is the bifurcation of Madhya Pradesh, MP, if my lord recollects, bifurcation of MP. As Jharkhand was carved out from Bihar, the same time Chhattisgarh was carved out from Madhya Pradesh. So, my lord, this case FIR came to be registered on 4th of January. After the police tried mediation and after making all the statements, recording all the statements, police at Raipur registered the FIR against the husband. Now, my lord, what happens is, the father of the husband holds a high post, my lord, here in NIPCO. He, as a counterblast, after they got the notices from the police, from Raipur, Chhattisgarh police, they all stay in Gurgaon, Haryana. He came to Bhalukpong, I apologize. Bhalukpong, he came to Bhalukpong and he lodges a report, not the husband, father of the husband. He lodges a report under section 3 against the daughter-in-law. Against the daughter-in-law.
Against the daughter-in-law.
Daughter-in-law and all the family members of daughter-in-law. Because they did not know the family members, my lords. It was through shadi.com. This, my lord, the father-in-law.
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 Okay.
He is responding number 2 here.
The daughter-in-law.
Against the daughter-in-law and the entire family of daughter-in-law. Even the grandfather, who is aged 80 years.
Okay.
Against them, he lodges a report, my lord. But the report is interesting. The husband doesn't come to lodge a report.
At Chhattisgarh,
the wife
lodged a complaint against everybody.
Against the husband.
Against the husband only.
And father-in-law and mother.
Okay. Husband, father-in-law, and mother-in-law.
So,
And here at Balong, the father-in-law, how he came here at Balong?
yes, that is what. Because, my lord, he held a high post in NIPCO. Electric Power Corporation of Arunachal.
Okay, he is working here.
He was working here. He was holding a high post of chairman cum managing director.
where the incident took place?
This is what I'm coming to, my lord.
Yes.
He lodges a report
Hmm.
saying that my daughter-in-law insisted to visit Arunachal. So she went with my son, that is the husband. And there she developed some illicit relations with some security officer at,
Where?
at Bhalukpur.
Okay. See,
And what he
as per
said,
his allegation, she came here at Balupong.
she came to Bhalukpur with the husband,
Hmm.
and husband saw her in an objectionable position. This is what the father-in-law is saying.
Hmm.
Her husband saw her in an objectionable position, compromising position with the security officer. And so he saw her in a compromising position, and interesting, my lord, not in a hotel, inside the bushes. Bhalukpong, a alien place for both of them. She enters into into an illicit relationship with the security officer, and she is found in an objectionable position by the side of the road in the bushes. This is the allegation. Nobody can imagine all this. Then, my lord, he says the husband objected, my son objected. So the wife, the daughter-in-law, and that security officer, I don't know who he is. Name is ATE something. M80. Mr. M80 and the wife assaulted the husband. This is the allegation. So, my lord, 341 and
Date, place given.
the place means the Bhalukpong itself. Nothing specified. And interestingly,
Date,
the
time
incident
given,
this
date and timing given.
date May they have given the May date.
Okay.
In the written complaint, the date is different. The FIR that is registered, date is different. 1 or 2 days difference. Interestingly, FIR is registered after 1 year of the incident.
Okay.
And according to his own FIR, incident was in May 22.
Hmm.
And FIR is lodged in May 23.
May 22 is prior to the complaint lodged by the little
Yes.
girl.
As per him, this is what the scene he stated.
Before the girl lodged FIR.
Before the girl lodged FIR, now he says, after getting the information about the girl's FIR, now he lodges a report of an incident 1 year back.
Okay.
He was sleeping. There's no explanation for 1 year.
Okay. But the case was registered under which section?
Case has been registered under 341, 323, 506, and 34.
Which is not,
341, of course, the sentence is less matter, but it is wrongful restraint. So that is the sentence.
2 years punishment?
No, it is
3.
wrongful restraint. I think it's 1 month. I think it was 1 month, my lord. It just confirmed.
Okay.
Could you please help me? So, my lord, this is what the counterblast by the father-in-law. Interestingly, husband has not come into the picture anywhere that I was assaulted. The victim is the husband. Victim is the husband, my lord.
Okay.
And my lord, even as per the FIR,
What is the
the
status
role
of
of the other family members, my lord, only 1 moment, my lord,
Yes.
can bear with me. Role of the other family members of the wife is that this father-in-law says in the same FIR, after all this happened in Bhalukpong, then I tried to persuade the family members who did not accede to my persuasion. Persuade that they tell your daughter to mend her ways. They did, instead of acceding to my persuasion, instead of mediation, they also threatened me. How? The mode of threatening is not. Now, if my lord, there was any threatening that he received in Gurgaon, so the jurisdiction would have been before Gurgaon police. Here also, my lord will appreciate one fact. My lord, for last more than 8, 9 months, 10 months, they did not accept the notice. Somehow or the other notices, this notice, no, what has happened? They did not accept notice. Then my friend filed an application for service of notice through Gurgaon police, which my lords allowed. It was allowed by this court. And only after they have been served by Gurgaon police that they have entered appearance, I suppose. They've entered appearance, sir? Yes. They've entered appearance.
They entered appearance?
Yeah, after they were served.
2 and 3.
And how they evaded notice by...
Yes. 2 and 3. Yes. And 4, respondent number 4?
4 is?
No, only 3 respondents. One is state, 2 and 3.
Former respondent.
for Mr. M.E.T. My lord, he is the same person who against whom the illicit relation has been alleged. So he is the formal response.
Notice was issued upon the proper respondent also.
No, that is
Respondent number
different.
4.
But my lord, the contesting respondents are here. Contesting respondents. He stands on the same pedestal as me.
The time will not permit.
Lordship, moreover, Lordship, we have called for the updated case study also, Lordship. We has not been received yet, Lordship. Yeah, Lordship. We have case study, but it is earlier one, Lordship.
The status of the case.
My
Lordship,
lord,
investigation
now-
stage,
Still
Lordship.
under
Just
investigation.
a moment, ma'am.
Investigation stage only, Lordship.
Every 15 days,
See, they have-
notice under 41A is sent to me.
During the investigation stage, is it possible?
Pardon, my lord?
The case is still under investigation stage.
I say, my lord, every day, every 10th day, the CO you call OC sends a 41A notice to us. Even the father-in-law of the grandfather, who's 80 years
You
old.
have never appeared before. Proceed.
But 3 of them appeared, the wife appeared, her father appeared, and uncle appeared. 3 of them appeared with the written representation and all the documents which are something that they had lodged the FIR and all those. And it is a counterblast. Now 3 of them appeared, my lord. The station house officer has
The
the
allegation in the FIR is not only against the girl.
about
It is
this
against the
incident,
family.
about this dirty incident, it is against the girl. But rest family members have been
Threatening part.
threatening part. And it does not say, my lord, if I read the FIR, even the FIR does not say that, it does not specify who threatened. 9 persons. What happened, my lord? The wedding card contains the names of the relatives.
You produce?
They from the wedding card, they took the names and inserted it in the FIR.
Okay. So you
Wedding
produce
invitation.
updated
Lordship.
case diary.
In any case, in this matter, I am appearing as a local counsel, but the conducting counsel is from Guwahati. So he has requested me to make and take adjournment for today. And this is the matter after.
Mr.
I'm Mrigendra Singh, senior advocate. I appear with Mr. Jaideep Kaurav,
This is item.
item 10, and Mr.
Mr.
I'm Mrigendra, MRIGENDR.
Mrigendra Singh, that is senior counsel, assisted by
Jaideep Kaur.
JD.
Wakalat Tamba is the local counsel.
Okay. Okay, let's get
We have come to, and I'm the designated
Assistant.
senior advocate, so I don't require a Wakalat Tamba.
Miss additional people, government people, and Mr.
I'm for my lord 2 and 3, respondent number 2 and 3.
Larry Council for the respondent number 2 and
3.
2 and 3. Stop. City was called for.
Last order.
We have also filed affidavit in opposition also. That may be.
Miss. Affidavit in opposition when?
The last one supply the copy. Yes.
Yes, I'll serve the copy.
Okay, Mr. Larry Council for the respondent number 2 and 3. Submits that he has filed affidavit in opposition. A copy of the same may be served, furnished to the Larry Council for the petitioner. When?
Today.
During the course of the days. They will stop. Miss L. Hagel, additional people. So, submits that the CD is not available now.
Lordship, this is updated CD may be called for Lordship.
Okay. Okay, it's prayed for by Ms. L. Hagel, PP. Some more time is given to produce the updated CD. Yes, that. Next date is fixed on. Fixed or just after 3?
My lord,
After 3
it could be fixed date, my lord.
Okay, it's prayed for by the Larry Council for the party.
24th would be fine, 24th. 24th of June only.
24th of
Because
June.
I'm receiving, they are receiving notices under 41. If that is stayed, my lord, then my lord, any date may be fixed.
Lordship, this
That part may be stayed. Because three persons, the girl herself, her father and uncle, they've all.
She appeared. Whether,
She appeared.
whether
She appeared,
was,
she
whether
initiated-
she was saying, no?
We find additional evidence. In that, we have
Whether she
submitted.
was so
I'm making a
arrested,
statement at bar, that girl, her father, and her uncle. Three
whether
had
they,
appeared.
any of them have been arrested?
No, they are available of it, all are.
Okay. Let's bring to Matrimonial Council for Party. This is
It's a 2,000 kilometers.
Lordship, it may be fixed, Lordship,
After
after,
break.
Lordship, because
This is
Balupong, Balupong PS,
far
Lordship,
away, it will be
Lordship.
bigger. For hard to obtain the.
No, we have
CD
Saturday, Sunday
Immediately,
also.
immediately after break.
after break,
Lordship.
then it will be in
But
July.
I would pray for a protection.
No, Lordship.
I'll pray for a.
Because Lordship, investigation stage,
So
Lordship,
when
is,
do you want? July?
My lord, June only, I wanted that,
June.
to take them in the next week, any date in the next week, my lord.
after court break, Lordship, because Lordship, Balupong is Lordship.
How long it
My
takes?
learned friend
How
will
long it
also
takes?
appreciate.
Lordship, the rainy season, Lordship, this road progress is also there, Lordship, that's why, Lordship.
Well, it
It will be on next week, because yesterday only I was in Balupong, there's no such problem.
And one
June
thing,
26 or
if my
27.
lord, we may be exempted from appearing before I would, because my lord, even I have come, I've come from there. This Chhattisgarh is around 2,000 kilometers. Even the ladies of the family have been implicated, mother of the girl, everyone. My lord, at least we may be exempted from appearing, and we may be permitted
Please,
to
this
submit
matter-
our
July-
written representation.
July, any days
Is vacation?
after vacation,
Yes.
any day?
Yes, any fixed date. Yeah.
Any date, my lord, any fixed date may be given. I'll.
22.
Because my friend staying here also. has
20,
come.
22, 22,
22nd of July.
22nd.
My lord, in the meanwhile, my lord.
In the meantime, in the meantime, the, no coercive measure will be taken. Okay, no coercive action shall be.
And
taken
I
against
undertake, my lord,
against accused persons.
I undertake, my lord, that all the accused persons,
Hmm.
barring those three who had appeared,
Hmm.
will submit in writing, through PDF, through email, they'll send their submission to both the other.
Lordship,
They
this is
join-
not,
They join the prosecution, my lord.
no,
But no.
Lordship, we have no record, Lordship, that's why I have called for the case study, Lordship.
No.
Lordship. Investigation should not be stopped, Lordship.
Copy today.
Okay.
No, rest, I think, we'll have to adjourn on it. No time. We are all petitioner, let's pray for, we'll have to adjourn. Let's pray for the Lani Council for the parties. This matter after a week. Interim is there? Okay, interim. The interim order passed earlier shall continue till the next day. Okay. List this matter after 2 weeks.
No, notice has to be issued, my lord. This is an appeal, my lord.
Notice.
LCR may be called for. Notice, my lord, LCR may be called for. That's all.
LCR not yet called.
Yeah, no, my lord.
Okay. Ask Mr. Lani Council to the petition. Also.
Appellant, my lord.
Also appellant, also have this. And have it, additional PP to the state and stuff. This is criminal.
Criminal appeal.
Jail appeal, Lordship.
The reports of the trial court would be necessary in the instant case.
Appeal may be admitted, my lord. Appeal may be admitted and LCR may be called.
What is this case about?
My lord, this is a peculiar case, my lord. 304, my lord. Conviction could not have been done, my lord, in any manner.
The case, the registered section was 302.
304.
304.
Yes, my lord. And 3 years, my lord.
The registered section itself is a 304.
Yes, my lord. And
Charge sheet file.
charge sheet file, it has been convicted, my lord.
Convicted also.
3 years, yes. The conviction could not have been done. That's my, my lord, argument, my lord. Section 304, that definition itself has not been fulfilled, my lord.
Appeal is admitted. Call for the LCR.
Yes. Maybe listed after 4 weeks.
Appeals. Whether taking steps upon the respondent.
My lord, the respondent is not necessary, my lord.
The informant not impeded.
No, my lord. This jail appeal, my lord.
Even then.
Yes,
Notice may be served, Lordship, but their affidavit is not necessary. Lordship.
Conviction of 3 years only, my lord. 304. If it's a heinous crime, my lord, notice would definitely be required.
List is made after, where, which court?
My lord,
Pasigat,
Pasigat, my lord.
Pasigat.
Yes, my lord.
Then after 4 weeks?
4 weeks, my lord.
List is made.
Yes, obliged.
Obliged.
May I, Your Lordship?
Yes, what is this? matter?
Your Lordship, this is criminal petition, Your Lordship. Yes, Your Lordship. And the last occasion, LCR was called for, and then same is received, Your Lordship, as per the case record, yes.
Your petitioner.
For the respondent number 2, Your Lordship. Yes, Your Lordship. So matter may be fixed for admission hearing.
Mr. Your Mr.
Jace Ring.
Yes. You are representing the state.
I'm from state, Lordship.
Additional people for the state. Also Mr. Jason. Also have Mr.
Jace Ring, yes.
Council for the respondent number
2.
2. The LCR call for has been received. List is matter after 3 weeks. The list is matter for admission hearing after 3 weeks. Okay.
Obliged, Your Lordship.
The criminal decision seeking the passing of the empire.
Scan copy was called for.
Lordship, we have, yes, sir. We have received this CD.
CD.
No, sir. Yes, Daddy. Ask for the
CD. The case is still under investigation.
No, sir.
This is problem.
No, my lord.
It is a problem.
No, my
It
lord.
is still under investigation.
Yes, yes.
Charge is not yet filed.
No, no, my lord.
No.
My lord, I am invoking this, my lord, principle, my lord, on mutual settlement. Because case arose out of
What is the
misunderstanding.
offense?
Offense, my lord will say only criminal trespass. Criminal trespass. Because 195
447, okay.
195A is not attractive. Because that section cannot be attractive in this case. So, on the basis, so my lord,
It's a joint petition.
joint petition by the complainant as well as the accused person.
You have received it.
No, sir. I've received a CD, Lordship.
Okay, then.
After vacation,
After vacation. Okay.
if my lord, now time, now it's going.
No, that I think.
That's why, my lord. Otherwise.
Mr. Sonar. Arsenal, also, Mr. Who submits that he had received the scanned copy of the LC.
But case study, Lordship.
Huh?
Case study you have received, Lordship.
Not LC, case.
No,
study.
Lordship. We have investigation, Lordship, under investigation.
Due to paucity of time, the case stand in list is matter
After summer vacation.
after vacation. On which date the Lanet additional PP still produced?
Updated. No, sir. Case study, Lordship.
Oh, sorry, case study. Because normally crossing petition should be only after the filing of charge sheet.
No, sir. Yes.
That is also there, but then you see.
482, my lord, says, my lord, FIR, my lord.
If I can be, Lordship.
But then there are also, judgment also, that
Okay.
during while it is still under investigation, it is trouble because we do not know
No, sir.
what will happen. But only after filing charge, if it is case, the case is pending before the court, okay, the person can be done.
But series of judgment, my lord, is showing, my lord. Even in the FIR itself, my lord, even FIR, if it doesn't disclose any case, and in case of non-heinous
No,
case.
because FIR, we do not know during the investigation period, how do we interfere with it?
No, when if law is saying, my lord, that if the FIR reading of the, their reading of the FIR, it doesn't disclose any cognizable case, how the investigation we can ever? There is the abuse of the process. A person,
FRC is also sometimes, you see, well also, FIR.
That's why, my lord, there should be some elements. And even, my lord, recent judgment day before yesterday, I was going to watch. Even says that, my lord, apex profile, even if FIR shows that there is a cognizable FIR, and during hearing, if courts finds that, no, this has been filed mala fide, then again it can be caused. then my.
That is why, probably it was himself.
My lord, and in cases, my lord, settlements are mutual settlement. In case of mutual settlement, my lord. Much better.
Okay, this is, I think, 15 is. Okay. Okay. 15.
May I please, Your
Yes,
Lordship?
madam. Ah.
In connection to item number 15, I have filed an IA application that is at item number 25 that may be taken up together.
25.
25.
25. This is item 15. Item 15 is for.
Item 15 is for quashing of FIR.
Fire.
Yes, in item 25, I have filed an IA.
Status of the case is still under investigation.
That is their part to say, Lordship. I don't, but I am the victim complainant and I have prayed for impleading me as respondent 3 in the item 15. Offense is 66 A
E.
or E of the IT Act. Allegation is that the nude pictures of the victim.
Can be impleaded? She's a necessary party then.
Your Lordship, actually, I am for the opposite party, number 1.
Who
I
is
have.
for the petitioner?
Oh, apparently is absent. Apparently is absent.
You are both of you are party, same party. Then if you are responding.
Your Lordship, I am the petitioner in item number 15.
Okay.
And I am the opposite party, number 1 in this one, item number 25.
Okay. So she is seeking, praying for impeding the.
In item number 25.
Item number 15 only.
25.
Yes.
Yes, Your Lord.
Yes.
Yes.
Okay.
For that, I have an obligation. Yeah, regarding the impleadment, I have an objection.
You have an objection also?
Yeah, I have an objection.
She is victim, I think.
Yes.
Yes, he is
She is
victim.
necessary party.
Yeah, but I don't think so, Your Lordship, because actually the entire allegation made by the is what informant.
She is the informant.
Yeah,
only.
informant,
Informant
applicant,
also.
informant also, applicant also. Applicant in IA, informant in FIR.
Yes.
Yeah. So in that case, I have an objection that since the
You want to
entire
file objection here.
yeah. Yes, Your Lordship.
Let him file objection.
Since
then.
the entire allegation has been
Miss Dangi, and counsel for the petition. I've also heard Mr.
R. Typodia.
Typodia, counsel, appearing for the respondent, opposite party number
1.
1. And Miss addition party PP for the state staff. This is an application praying for impleadment of the applicant as respondent party number 3 in criminal petition number 779 AP 2024. The opposite party number 1 wants to file an objection. List this matter on the list this matter after 3 weeks. 3 weeks. Okay. Item 15.
Lordship, a date may be fixed. It's a very short question.
Well,
Your Lordship,
you file with
I have
a
an
week then.
I have a submission in
28.
in item number 15. Today, actually, the date was fixed for furnishing of records by the learned PP.
And in main case,
Yeah.
Mr. Arthur, and counsel for the petitioner. I've also heard Ms. Petition people.
Lordship, we have received the case diary, Lordship.
Yes, Jerry.
Lordship.
Then today, it will not be possible now. Day after tomorrow. No, case diary. The next week, we'll fix it next week. Okay. Let's pray for by the non-council for the party. This is matter on 27. And they are also in file before 27. Okay. Okay. This also on 27. Let's pray for by the non-council for the parties. This is matter on 27. Okay.
Then Lordship, updated case study, Lordship, because this case study is retained or
Case diary, in that case, in the main case then, on which date, fixed on 27th, on which date the landed petition PP shall produce the updated case diary.
तुम्हें आइटम नंबर वो था ना उसमें उसका नाम को रिफ्लेक्ट करना है